Able to you?
The path towards attainment of peace is always full of hurdles. However, legal deliberations can act as an important scaffolding for the construction of a peaceful culture. The legal fraternity is envisioned to be the harbinger of hope that will lead human beings towards harmony. Law indeed is the means to attain the ultimate goal of peace through amicable dispute settlement, and therefore this International Symposium has been incepted to herald law to promote peace. The first International Symposium on Law and Peace, which is organized by MIT WPU School of Law, aims to become one of the brightest beacons to herald peace and harmony through the lens of the law. The ISLP strives to provide a common platform to legal professionals, youth, policy planners, thinkers, and global society at large, where they can come together for dialogue, open discussions, deliberations, and can use the platform to recommend measures to address conflict resolution through peace-building processes, to promote the culture of peace and harmony for a digitally dynamic and complex society. The main mission of arranging the Symposium on Law and Peace is to promote peace and harmony in global society through lawmaking processes and policy decisions by imbibing the principles of justice, equity, and good conscience, sensitizing budding legal professionals as conflict resolution ambassadors, to initiate dialogue between lawyers, judges, policymakers, jurists, academicians, the youth, society, and industry about legal dimensions and peace perspectives. Law is there for us when we are there with the law. Let's make the best out of this golden opportunity. Welcome to the first International Symposium on Law and Peace.
Fake news generally refers to journalistic articles that intentionally or unintentionally confirm false or inaccurate information. False information can spread like wildfire without counteracting the investigation and fact-checking that journalists traditionally carry out. Often written with an emotional appeal, to be disseminated based on vitality rather than truthfulness, and there are clear financial incentives to maximize the production and distribution of this information. And this is one of the key challenges of our time. Misinformation erodes trust in institutions and undermines democratic processes. In an online world of misinformation, trust is a powerful weapon for retaining audiences and advertisers and standing apart from the noise. This session will shed light upon this phenomena of unlocking fake news by regulation that will briefly give an insight on the importance of this issue, as it is not just a technical problem but also a social and economic one.
DNA profiling is the profiling of people on the basis of DNA material that is harvested from a person or a sample of bodily tissue. Although for the most part DNA in humans is majorly similar, a small part of our DNA is unique to all people, just like our fingerprints. DNA profiling has been an emerging field and has been greatly helpful in criminal investigations, discovering family and even victim identification in times of natural disasters. DNA profiling is greatly being used in criminal investigations, with DNA databases now being merged across jurisdictions for investigative agencies to access and do quick identifications of victims or suspects. DNA profiling has now advanced to MPS, massively parallel sequencing technologies, which even helps in identifying genetic material which run thousands of sequences at once to ensure quick identification. DNA profiling has varied and great usage mainly in forensic and medical fields, with newer and faster technologies coming up every day. Let's discuss in this session the functioning and legal applications of DNA profiling. It has now become a well accepted fact that artificial intelligence is changing human society as a whole. It is an instrumental part in all tangents of life, whether it is to open a lock on your phone or help track and analyze various types of diseases. AI is being used everywhere. But is it available for everyone? Human rights, as we all know, are universally protected and are the most intrinsic rights that cannot be denied to anyone. Society is seeing a shift where robots and machines are evolving social systems. But is artificial intelligence doing so without any social, racial, and economic bias? Is AI going to be another tool of discrimination? Would AI lead to a new form of oppression? These questions need to be answered. The session would help find these answers and shed light on a topic that needs everyone's attention. Let's discuss in this session the various aspects about human rights laws and artificial intelligence. Intellectual property rights and competition law are two distinct fields of law that have become of paramount importance, especially in the ever-growing corporate industry, with upcoming entrepreneurs, established businessmen and innovators competing in cutthroat competition in a bid to win over the consumers in all fields ranging from agriculture to information technology. Competition law governs the companies and establishes standards to be followed so that cutthroat competition doesn't lead to consumers being affected by unfair trade qualities and under-quality goods. IPR protects the businessmen and innovators by safeguarding their unique business creations from being copied or misused by anyone. While in theory, these laws may not seem related to each other, in reality, they have led to one big common incentive for the final consumer: a competitive and innovative developing market. These laws have become the perfect recipe to ensure innovation in compliance with ethical and legal standards, combined with the legal protection to protect the efforts that go behind them. This session will discuss the interface between intellectual property rights and competition law.
The role of a witness is very crucial in determining the outcome of a case. The party producing the witness in the court tends to give a favorable testimony on behalf of the party that has produced him, and the testimony of such a witness is negated by the adverse party. A tough situation arises when the favorable witness turns hostile. The credibility of the testimony of such a witness and the impeachment of the credibility of his testimony unnecessarily leads to the prolonged trial of a case, which in turn vitiates the direction of the court in its quest for truth. In case if a prime witness in a case turns hostile, the court in that case will have to search for other circumstantial evidence in reaching a conclusion for the case. The fate of a case will be doomed if, on a crucial aspect of the case, the court will have to dispense with the testimony of the witness and depend on circumstantial evidence. The session will deal with issues like what leads to a witness turning hostile, what is the truth behind the testimony of the witness, and so on and so forth.
Have logged in, and all the students who have been sent a request for the panelist link, please do join from the panelist link. A warm good evening, good afternoon, and good morning to this August gathering and to all the participants joining from different parts of the world. I, Professor Chandrika Basu, welcome you on behalf of Dr. Vishwanath Karad, MIT Walpise University School of Law, to the first International Symposium of Law and Peace on the theme, the role of law to promote the culture of peace. Before we embark on this thought-provoking journey of knowledge, as per the traditions of MIT Walpise University, blessings with the World Peace Prayer, a prayer that is above any caste, creed, or religion. So a humble request to all of you With closed eyes and folded hands, let's remember our Almighty. I request my technical team to relay the World Peace Prayer.
Om Namo Jiyadya Veda Pratipadya Jaya Jaya Swasamvedya Atmarupa Devatuti Ganeshu Sakalartha Mati Prakashu Mhane Nivrittidasu Avadhari Goji Gurur Brahma Gurur Vishnu Gurur Devo Maheshwara Guru Sakshat Parabrahma Tasmai Shri Gurave Namaha Purnamada Purnamidam Purnat Purnamudachyate Purnasya Purnamadaya Purnamevavasishyate Om Shanti Shanti Shanti.
Thank you so much. Dear delegates, after witnessing an overwhelming participation from participants all over the world in the first 3 days of the first International Symposium on Law and Peace, organized by MIT World Peace University in association with Pune District Bar Association, ladies and gentlemen, I welcome you to plenary session 8, which is on the theme, the legal education in the 21st century. We are about to witness a very interesting deliberation from all the dignitaries who have joined us from different parts of the world. Ladies and gentlemen, it is indeed my honor and privilege to introduce the moderator of the session, Dr. Manoj Singh, Associate Professor, National Law University, Jodhpur. Dr. Manoj Kumar Singh is working as an Associate Professor in National Law University, Jodhpur. He has a teaching experience of 14 years in the field of taxation. He is a postgraduate in law from Banaras University. He has professional experience as a lawyer of 2 years. He has attended workshops and conferences at various levels in relation to corporate law and taxation. His area of interest is taxation and commercial laws. He is the Executive Director, Center for Tax Laws. He is the Placement Director at National Law University, Jodhpur. He has published papers on various issues relating to taxation in the journals of national and international repute. A hearty welcome to you, sir. Ladies and gentlemen, I'm extremely happy to introduce the first speaker of the session, Dr. Sangeeta Laha, Associate Professor and Dean, National University of Study and Research in Law, Ranchi. Dr. Sangeeta Laha has pursued MA in Political Science, MBA, LLB, LLM, PhD in Law from the University of Calcutta. She has published many research papers in international and national journals. She has also published a book titled Women and Legal Profession in Indian Context. A hearty welcome to you, madam. Ladies and gentlemen, it's indeed my honor to introduce the next speaker of the session, Dr. Nasim Amir Ali, Associate Professor and Director of Internationalization, School of Built Environment, Massey University, New Zealand. Dr. Ali has 30 years of combined experience in the construction industry and academia in Malaysia, United Kingdom, and New Zealand. Current primary interest is in construction law, adjudication, and other alternative dispute resolution methods, drafting modern plain English construction contracts, construction project management, and quantity surveying. A hearty welcome to you, sir. Ladies and gentlemen, please join with me in introducing the next speaker of the session, Dr. Priyanka Zaude, Legal Officer, Law and Treaty Division, Ministry of External Affairs, Government of India. Dr. Zaude is an alumnus of International School on Nuclear Laws by the Nuclear Energy Agency and also holds a university diploma in International Nuclear Law from University of Montpellier, France. At present, she is postdoctoral fellow and working on outer space liability and use of nuclear substances, international and national law and policy. Both her PhD and postdoctoral work is at the Department of Law, Savitribai Phule Pune University. In June 2019, her research work was appreciated and she got an opportunity to present it at the International Conference at the United Nations Specialized Agency, International Atomic Energy Agency, at the head office in Vienna, Austria. We welcome you, madam. It's indeed my honor to introduce the next speaker of the session, Mr. Sylvester Udemezu, lecturer, Nigerian Law School, Lagos Campus, Yanagoa Campus. Mr. Sylvester Udemezu is a profound legal practitioner and a law teacher. Served was a lecturer in Nigerian Law School, Lagos Campus from 2007 to 2019. Currently, he is a lecturer in Yanagoa Campus. He is also working as a counselor, law consultant, and researcher. He is a renowned advocate of rule of law, public speaker, writer, and public legal affairs analyst and humanist. We welcome you, sir. Ladies and gentlemen, please join me in welcoming the next speaker of the session, Mr. Utkarsh K. Mishra, Assistant Registrar, Supreme Court of India, New Delhi. Mr. Mishra is currently on deputation to the Supreme Court of India as Assistant Registrar cum Assistant Fellow in the Center for Research and Planning, Secretariat of Honorable Chief Justice of India. He is on leave from the Dharmashastra National Law University, Jabalpur, as Assistant Professor of Law. He is also a teacher and researcher by profession and passion. He also heads the Research Institute for Studies in International Trade and Investment Laws at the university. In addition, he also teaches international trade law, contract laws, private international law, legal methods, and critical theory. We welcome you, sir. Now, I shall request Professor Anuradha Parasar, Dean, School of Law, Faculty of Liberal Arts, School of Visual Arts, and School of Performing Arts to address the gathering. Over to you, ma'am.
Thank you, Dr. Basu, and Sadar Namaskar to one and all, respected dignitaries on the dais, distinguished honorable members of legal fraternity who are attending this symposium online, as well as those who are present here, respected Honorable Chief Justice, Honorable Justice of Supreme Court, High Courts, Honorable Sitting Judges, Honorable Former Judges, distinguished senior advocates, members of Bar Association, advocates, lawyers, fellow colleagues, participants, members from media and press, faculty, staff, and my dear students. A very good afternoon to one and all. As per Indian Standard Time, it's 2 o'clock, 2:10 in fact in India. So please accept my heartfelt greetings as per the respective time zone, and welcome one and all to this technical session on legal education on 21st century of this prestigious symposium, International Symposium on Law and Peace at Dr. Vishnath Karad, MIT World Peace University, Pune, Bharat. MIT World Peace University, it is organizing this conference in association with Pune District Bar Association And the theme of the conference is Role of Law to Promote the Culture of Peace. We started the symposium with a very grand inaugural session on December 14th. And after this session, this is the last technical session of this symposium. After this technical session at 4:30, we will be concluding this successful symposium with the valedictory session. So at the outset, I wish to express gratitude and thanks to a good number of people who contributed in making this symposium successful. So first of all, I wish to express gratitude and thanks to Honorable Revered Professor Dr. Vishwanath D. Karad, who is President MIT World Peace University. And we express gratitude to MIT WPU's International Symposium on Law and Peace patrons and organizing chairs, Honorable Executive President Shri Rahul V. Karad, and to Dr. Lalit Bhasinji. And thanks to Professor Ravi Kumar Chitnis, Vice Chancellor MIT WPU. And we also express gratitude to MIT World Peace University's School of Law Advisory Board members. And there are a good number of names I need to acknowledge. Shri Nanik Rupani, Justice Dilip Karnik, Advocate Makarand Adkar, Advocate Satish Manishande, Advocate Anand Desai, Advocate Aniket Nikam, Advocate Ravi Kinai, Advocate Rajendra Shirodkar, Advocate Mohan Pungalia, Advocate Mrunalini Deshmukh, Professor Dr. K.L. Bhatia, Professor Dr. Dilip Uke, Advocate Sudhir Vakure, Advocate Anita Agarwal, Advocate Aditya Pratap, Advocate Komal Joshi, Advocate Kapil Kher, and Advocate Satish Mulek. I also take this opportunity to welcome and express gratitude to all distinguished speakers of today's session, this technical session, all the legal luminaries who are gracing right now the virtual dais of International Symposium on Law and Peace. And we keenly look forward to your address on legal education in 21st century. Thank you. Vande Mataram. Jai Hind.
Thank you, ma'am. Thank you so much for perfectly setting the tone of the session. Now I shall request Dr. Preeti Joshi, Head of School, Faculty of Liberal Arts, for the welcome address. Over to you, ma'am.
Thank you, Dr. Chanika. A very good afternoon, good morning, and good evening to all the guest speakers, dignitaries, and participants, as per the respective time zones, as ma'am said in the address remark. I, Dr. Preeti Joshi, on behalf of MIT World Peace University, welcome this August gathering in this very unique International Symposium on Law and Peace, ISLP. And the theme is Role of Law to Promote Peace. This symposium is organized by the School of Law, MIT World Peace University, in association with the Pune District Bar Association. I feel honored to welcome all the eminent, veteran, distinguished personalities across the globe contributing to this symposium. There are more than 80 experts, more than 19 different countries paneled here in the threadbare discussions and deliberations in all the sessions of the symposium. This present session that talks about legal education in 21st century. Actually, any elements of legal education are influenced by the new dynamics and the changes that have emerged in the society. And as a result, legal education needs to broaden in order for law students and the practitioners to have a beneficial impact on today's world. And now we all can see that in India, legal education is undergoing significant changes. Success currently appears very different than it did in the past. So giving students the skills and helping them to gain the confidence to use those skills, that is at the core of 21st century education, I feel. And in the recent years, legal education and development have become intertwined notions. All of us know that. And many changes have occurred in the field of legal education as a result of this digital age. And this digital age represents an opportunity to revitalize and modernize legal education by making it more individualized, relevant, humanistic, and accessible, I feel. And this exactly is the aim of this session, to discuss the scope and evolution of legal education in 21st century today. So wholeheartedly, I welcome the eminent guest of this session, Dr. Sangeeta Laha, Associate Professor and Dean, National University of Study and Research in Law, Ranchi, Dr. Naseem Amir Ali, Associate Professor and Director of Internationalizations School of Built Environment, Massey University, New Zealand. Dr. Priyanka Javle, Legal Officer at the Law and Treaty Division for the Ministry of External Affairs, Government of India, and the Postdoctoral Fellow. Welcome, ma'am. The next distinguished speaker we have, that is Mr. Sylvester Damazo. He is a lecturer, Nigerian Law School, Yen Goa campus. We do have Mr. Utkarsh Mishra, who is an Assistant Registrar, Supreme Court of India, New Delhi, Bharat. And the moderator of today's session, Dr. Manoj Kumar Singh, Associate Professor, National Law University, Jodhpur, Bharat. So once again, wholeheartedly, I welcome you all to this session, which talks about legal education in 21st century, International Symposium on Law and Peace. Welcome you all. Thank you. Over to you, Dr. Basu.
Thank you, ma'am. Thank you so much. My dear student friends and all the delegates, there are certain moments in life that we wish to treasure throughout. And this being one such moment, we will not let this opportunity just pass by. So a humble request to all the panel members to put on their videos with a beautiful smile on their face so that this moment can be captured for a lifetime. Thank you. Thank you so much. According to Justice Krishna Iyer, profession of law is a noble calling and the members of the legal profession occupy a very high status. Law is the foundation of every society and it develops the abiding citizens, lawyers, academicians, and aspiring judges. Historically speaking, the legal education traces back to ancient period where the kings and princes were given teachings about dharma and nyaya. In fact, many of our freedom fighters were also from legal background. It includes the profession which is practiced in the court of law, law research, and administration in different branches where law plays a pivotal role. It injects a sense of equality before law. Legal education should not only produce lawyers, but should be regarded as a legal instrument for social design. Is the legal education in the 21st century serving the purpose? Let's discuss. Before formally handing over the session to the moderator, Dr. Manoj Kumar Singh, I shall request my technical team to relay the session video. Over to my technical team.
Many elements of legal education are influenced by the new dynamics and changes that have emerged in society. As a result, legal education needs to broaden in order for law students, and practitioners to have a beneficial impact on today's world. In India, legal education is undergoing significant changes. Success currently appears to be different than it did in the past. Giving students the skills they need to succeed in this new environment, as well as helping them gain the confidence to use those skills, is at the core of a 21st century education. In recent years, legal education and development have become intertwined notions. Many changes have occurred in the field of legal education as a result of the digital age. The digital age presents an opportunity to revitalize and modernize legal education by making it more individualized, relevant, humanistic, and accessible. The aim of the session is to discuss the scope and evolution of legal education in the 21st century.
Thank you for that lovely session video. Now I shall formally hand over the session to Dr. Manoj Kumar Singh. Over to you, sir.
Shanika, I hope audible to everyone.
Yes, sir.
Okay. I warmly welcome all the learned speakers of this panel. And I hope the session will be fruitful and will achieve the goal also of this symposium, because I saw that goal which has been written in the plate of the symposium, that how the rule of law and its impact on peace and harmony, the ethical legal practices and the effectiveness of legal framework, how to bring the balance between law, justice, and the changing needs of the society exploring measures and directions. So all the things we can achieve through a legal education, a high quality legal education, we can say. I had an honor to listen to our Honorable Chief Justice of India, Justice N.V. Ramanna, in one of the convocation address, and he was talking about the true education. And I'll quote that what he said about the true education, and it applied to a legal education as well, because he was talking to the law students itself. Now he said, in quote, that true education also focuses on its moral or spiritual functions, which broaden thinkings and help develop social consciousness. And he also said that the true education is one which imbibe the moral values and the virtues of the humanity, discipline, selflessness, compassion, tolerance, forgiveness, and the mutual respect. So he was basically talking about that how we can improve our education system, including that legal education we are talking about. These modern education, if you talk about these, the law schools are the other colleges which are there since 1980s. These education system focuses basically on the utilitarian aspect of the education, and it is not equipped to deal with its moral or spiritual function, and that is the goal of the education. Because what Swami Vivekananda has said about the education, he said that education is the manifestation of the perfection of that's already in the man. So it's just not talking about the facts, because even just I want to quote Albert Einstein also, that he talked about on the education, and he said that education is not the learning of the facts, but it's the training of the mind to think. So, and that's a whole purpose of the law education itself. Law education is to provide an ability to apply the law in a given situation. And it's just not about the information, it is the knowledge which has to be created through that information. Nowadays, we are also very, we can say that it's a positive things of the legal education, that now we are getting very good students and they are updated because of the technological advancements. Now they have all the informations, okay, whether you talked about the relevant cases, the contemporary cases, they have all the information. So that the blending of the traditional subjects with the contemporary laws, it's required. Now everything is, we can say, is a cross border. So whatever law we can think is has the cross-border implications or applications. So how we can apply that laws in a given situation where the it's a transactional, it's a trans-border situations are there. And I can see that on the panelist, that Dr. Priyanka Jawli also, he is a part of the external affairs treaty negotiation. Now, treaty negotiation is one of the very important key factors in the law education, because you see, I just talked about the double taxation avoidance agreements. Now, it takes a lot of time on a single point, like a comma, full stop. Okay, these words, how to choose these words in that negotiation, and it took like a year to decide on a particular area, that whether it is suitable to the source country or should be suitable to the resident country. So the whole aspect of treaty negotiation, so that is contemporary, but we have to blend with the basic knowledge about the taxation, that what is the all taxation system, what is the economic impact of taxation system. So it is just not in isolation we can think about the treaty negotiation as a contemporary issue, and forgetting that the basic structure of the economic impact of the taxation, because it is we have to blend that. So our legal education, there are I can say that there are so many things now. The legal education or any education we can see is a part of the concurrent list, whether the center has also power, the state has also power. Legal education as such not mentioned like a technical education or medical education, which is find part of the seventh schedule. I think that legal education should also be mentioned there, because it's a core area of any, we can say, the societal change or a development in a society. It's a core area. So like medicine or other technical education, this will also be find place in the seventh schedule as a specific measure itself. Now, there are, we can say that various things, they are part of the legal education system. And what are the primary function of law. I think the speakers will talk about the detail about the primary function of law and how we can imbibe that within the students and how we can. So basically, there are so many things we can say that a part of the education system, and there are certain issues also which have to be looked into. That how this in changing societies, we said we can influence these things. There are government policies which influence these law education. There are like a regulatory, like a BCI, we can see that the Bar Council of India, that even along with the UGC, so that the tussle is always there with the UGC and the Bar Council, that okay, how to apply and what to follow, what to not to follow. Because that BCI and UGC both are, we can say, the regulatory body for a law education. I can say that there are affiliating universities. That is also, we can say, that factors which are influencing the legal educations. There are national litigation policy, that what is, suppose in future we are allowing the foreign law firms to practice in India. So whether we are prepared for that, whether we had a proper high quality education system, legal education system, to basically prepare the student to compete with the foreign law firms in India itself, because they have to find out the advocates within India. It's not like they are bringing the advocates from outside. They have to find out that. So we have to prepare out there. So the national litigation policy is also one of the very important factors which are influencing the legal education. Then there are, we can say, the infrastructure issue, that faculty is also part of the infrastructure. But how we can get the good faculty, how we can develop our faculty, how we can groom our faculties, how we can have the training sessions or modules to develop the faculties, because getting a good faculty is also very important issue for legal education. The other infrastructure, like a proper, I have seen so many places that in North India, that there are not a good place. There is just two rooms in a building, and they are having the law colleges, running in the law colleges, okay, without having the proper infrastructure. And like we can see that more than we can say near about 1 million students are like enrolled as a in the these different law colleges, in universities are like that itself. Okay, where is the we can say the job for these so many? And that's why the Bar Council also has come along with the entrance examination or the enrollment examination, like that. So these are the so many issues, and I think that the speakers definitely will touch upon these things. There are panels of the learned speakers. So I will just not talked about in detail about thing. I think the panel is, I'm just handing over to the speakers to discuss about that. And at the end, we can take the questions from the participants or from the any other even the from the panelists also, we can take that. And I request Chanika to, if the questions are there in the chat box, so they can collate these questions, and then at the end we can deliberate on that itself. And the another thing that I think we had the 10 minutes for the each panelist. So I think we should make it in a time frame. So I would like to first invite Dr. Sangeeta Laha to deliver his discussion and to the participants. Thank you.
Namaskar. Am I audible? Am I audible and visible? If not visible, audible. Am I audible?
You are.
Yes,
You are.
yes.
You are.
Yeah, thank you. Connecting through this internet, which has introduced us in a legal education itself, is a boon. So although we lost a lot of lives in Corona, in the last pandemic, but one thing we learned as a faculty of law is that we got connected throughout the world. And this internet itself is a boon, a plus point in legal education in India. So if that way we got connected, otherwise all of us were frog in that well. Thank you, Dr. Professor Anuradha Parasar, Dean School of Law. Thank you, Dr. Manoj Kumar Singh, sir, Thank you, Dr. Purnima Imandar, Head School of Law, MIT, for inviting me in this to share some of my thoughts to be and put some of my points across. Greetings from my side to the students who have joined to patiently listen to me, and I'm sure they will bear with me for 10 minutes. My experience, I have spent half of my decades of my career with NLUs. I started my career in NLU Kolkata. Sometime I had the opportunity to serve a private university of repute, came across, served CNLU, NLU Patna. Now I'm serving NLU Ranchi. So half of my career I have devoted myself spreading a little bit, whatever little I have, teaching students and trying to build them. Now, talking about the 21st, how legal education have moved into 20th century. The traditional university of 2-year, hello, am I available? Am I audible?
Yes,
Hello?
ma'am.
Yeah. From 21st century to the 21st century, what we had during independence, my parents having 3-year law course, then I entered into it, then switching from 1986 to the 5-year course, it shows a revolutionary aspect in legal education, and much to my respect and regard goes to the then my professor and guru, Professor Madhav Menon, who my batch of faculty members must be knowing him, who pioneered and paved the way for 5-year legal education in India. Now, higher education itself in India is the 3rd largest in the world next to China and USA. And this is the statistics of the World Bank, through which I'm stating. Although IITs and IIMs and ISI, Indian Institute of Science, was well established after independence, not much importance was given to legal education in India. And as a result, the view of lawyers in the society had degraded, but maximum lawyers who fought in the freedom movement were lawyers. So we felt, or we see a downward trend in the legal education, maybe after independence in 16 and 17s. And then there was a feeling that we don't get good students in the bar. And just now, Dr. Manoj Kumar Singh had pointed out that lately we have started getting good students. And why? Why is the reason? Because legal education, law is now taken as a professional study, which it was not taken before. So you see, there was a change in the look, change in the mindset of current of the students in the last 10 to 12, 15 years. And this change, again, was supplemented by internships, by recruitment, and sort of students, young youth started thinking, and we had students who left IIT, got a chance in IIT and IIMs, but preferred studying law. So what was the reason behind? Obviously, it was the pay and the perks that students from NLU started getting in, especially first from Bangalore, Hyderabad, Kolkata, all these 3, which are still on the higher edge. Students from these universities started getting good pay perks after passing out. So that was another reason why the look of the legal education started changing in. So the first challenge, these 5-year courses, either in traditional university like Delhi University, Mumbai University, Pune University, University of Calcutta, all these universities. So whether student passes out from traditional university or for NLUs, we find that there has been a change in mindsets, change in the look of the university, and primarily because legal education in the last 10 to 12 years have started taking a serious note. Secondly, the courses that was structured earlier, there has been a change in the course structure. First 2 years, what we find, and you and I agree on this platform, is we have a combination of, if it is BLLB, a combination of management and law courses. If it is BLLB, we have a combination of arts and law courses. In some universities like NUJs, where I had taught, it was BSc LLB, so combination of science and law colleges. So it was not just purely law, number one. Number two is that it was 10 plus 2 plus 5. So right from after plus 2, the student could get into a technical course, which he or she knew, once if I pass out, I have a good care. Second point, the next point is this part of India where I'm teaching, such as in UP, in Bihar, where lot of priority is given to students entering judicial service, because they know government jobs has got security, it has got prestige and social status other than fetching a good dowry amount. So students from passing out NLUs from Lucknow or from Patna and from Ranchi, they do not go into corporate firms, but their bend is towards procedure law, master procedure laws, and they crack judicial service examination. And all the 3 NLUs are now producing more students in the judiciary who are good students, whom I believe will come out with good judgments, because they have studied law properly in the last 5 years. So there is another mindset. Whereas students from NLU Kolkata, or maybe from Mumbai, or maybe from their industries, their mindset is joined into law firms and corporate firms. So they more concentrate on the areas, the corporate law areas, the arbitration area, so that today if they join like associates, they may land with partners. And I have students who are minting a lot of money becoming partners of law firms that passed out from NUJS Kolkata, and also the passing out from Symbiosis Pune. So what I want to say is, now legal education, like medical or like IITs, is taken very seriously. The 5-year course has brought a lot of serious. Unfortunately, the other side of the story is, and to quote the late Professor Madhav Menon, we are having actually 2 sets of students passing out. One 5-year course passing out from traditional university, whose mindsets are different, and one passing out from the national law universities, students from good, whose background is good, who can pay well, because NLUs have got good fat fee structure. And as a result, NLUs are also missing good set of brainy students who have merit, but who do not have the ability to pay that much of fees that the NLUs demand. So are we then trying to build 2 sets of students from different universities? One, like from traditional and good universities, because I've got a lot of respect for traditional universities, and the second set who pass out from NLUs. And nowadays, what I feel, being a faculty of one of the NLUs in India, is there's a lot of a craze to get a degree from NLU. If not, let me have an LLM, because LLM is another 1-year course that has been introduced, which have received a lot of criticism. It is a cut short way of getting a postdoctorate degree. I'm afraid how it gets a postdoctorate degree, it should have been a diploma course. Secondly, people who do not get LLM, who wants to become faculty like me, wants to get a PhD from any of the NLUs, because they know at the end of the day, if they have a degree from any of the NLUs in India, they are assured of the job. And last but not the least, I have also seen that students after graduating out have a yearning of getting one LLM course from abroad. Because if they come back to the Indian market, and few law universities, private universities that has come out in Delhi or many parts of India, they have a hankering for a foreign degree, because even though the Britishers have left us, there's a hanker that we must have a foreign degree. So we are producing students of different kinds, although legal education has changed the mindset of the people in the society. We have brought good students in this field, but yet there is a lot to develop. As Dr. Singh just now pointed out, my former speaker just now pointed out, we do not even of the law colleges not even have proper infrastructure. So how would they impart legal education? Two, some law colleges are also giving degrees through distant education. I'm afraid without any practical knowledge of law, how would such students, what would such students learn? Third, there are proper course structures. Still, we do not have practical oriented course structures, although in many of the NLUs and many of the traditional universities, moot court is essential. Students are craving to participate in moot court because there is an instant fame of becoming a good mooter. There is, as such, no practical training, whether 1 month of internship is enough to know the lower court proceedings or the high court proceedings. So therefore, the course till date is not practical oriented. Although Professor Madhav, late Professor Madhav Menon was more on clinical education, do we teach that way mediation and conciliation? I'm afraid we do not, many of the law schools or the law universities do not have a court structure that way. The Bar Council has done a lot of reforms. I cannot ignore that. But Bar Council or the UGC, especially UGC, is every time coming out with new education policy, which becomes difficult for the university to understand. And there is a clash regarding the supremacy between the Bar Council and the UGC, and with the new education policy of 2020, actually doesn't give much of importance to the UGC. So, things have started changing so much that many of us, a lot of us are in it of mind. There is also not proper recruitment of meritorious faculties, because sometimes UGC says essential. Now the rule is PhD is essential criteria. Then the recruitment process is also not transparent. As a result, good professors do not reach to the higher echelons, or there are professors who are not so good in teaching because of some other good activities or other activities, get good promotion. So that way, higher education or higher echelons, we have a vacuum in the top level in the university, both in academic administration as well in teaching. So although the 5-year system was adopted in 1987, that was established in Bangalore by the 184th Law Commission of India, which suggested harmonious construction of UGC and BCI, but I'm afraid they do not meet on equal terms. Also, there are foreign investments that also coming to India in education sector that has also raised the standard of legal education in private sector. So do the syllabi is up to that mark? Have we changed and brought reforms in our syllabi so that students, if they want to go abroad or if they want to enter into the private sector, it meets such challenges? Or are we trying students who can become foreign lawyers and can also argue in different parts of the world? So that also needs to be looked into. Students should be given more and more encouragement to participate in moot court and international moot court so that they can go, they know what are the challenges in the globally. And more emphasis should be given on international dispute resolution, maritime law, investment law, banking law, other than the procedure law that is taught in the initial stages of legal education. I do not think, I think I have I crossed more than 10 minutes? Have I taken more than 10 minutes? If so, I am sorry, I have to restrain myself because I can go more and more. But because of the restriction and the slot given to me, I cannot go beyond that. But I must say that legal education has brought a lot of revolution in India, but much needs to be done in way of infrastructure.
Sir, I think there's a technical glitch.
Yes, I think so.
Yes.
Thank you, Dr. Sangeeta, for your valuable inputs. Now I would like to invite Dr.
In the library.
Dr. Naseem Amir Ali for discussing his thoughts on this role of legal in the 21st century. Yeah, thank you.
Can I have the rights to share the screen, please?
Rights are given. So rights are given. If you could just kindly check once.
You can share your screen, sir. There is no problem. It's already there on this.
I can't. It says host is disabled, so either make me a co-host temporarily.
I request my technical team to please give the sharing rights and confirm me once the rights are given. Technical team, please let me know as the sharing rights are given.
It's given.
Okay, I'll try now. No, it still says host disabled, participant sharing, screen sharing.
Technical team is still unable to share. If you all could cross-check once.
Oh, okay, I'm co-host now. I think I should, yes, I can share it now. Right, thank you. Can I just get confirmation that you can see my PowerPoint slides? Yes?
Yes, sir.
Okay,
Yes.
thank you. Let me just make sure that I'm checking the time as well. Okay. Good afternoon, good evening, everyone. Thank you for inviting me. It's in the evening, about 10 o'clock, 10:20 in the evening in New Zealand now. I'm really pleased to be able to share with you. Now, I just want to start with a disclaimer, first of all. I'm not a lawyer. Yes, I've got a master's in construction law from King's College in London and so on. I'm a professional in the construction industry, and I teach construction law. I teach adjudication, arbitration, mediation, but I'm not a lawyer. So with that disclaimer, let me continue. Now, a key theme of what it is that I'm going to talk about today is basically back to basics in order to get to the future. That is a key message. And I'll share with you my slides as we go along. I note 4 keywords from the conference: law, peace, legal education, 21st century. Law is an overriding theme, understood. Peace means we don't want, and peace includes not just about physically going to war. We don't want to go into court and end up in a massive dispute. But the key thing is, what is the role of legal education and particularly in the 21st century. So with those keywords, I now go to the next slide, and that is, what is this? If you ask a lawyer, some might say it's a cat. Others might say, oh, no, no, no. It's a series of triangles and a square and a trapezium. So lawyers will interpret to suit whatever it is that they require. But always remember, there is a duty as a professional to make sure that they do justice to society, not just their self-interest. This clearly, nobody's going to argue. It's a cat. It's a cute cat. And so is this, a smiling cat. But it gets a little bit vague because sometimes lawyers would argue, technically speaking, this is also a cat, but it's not a friendly cat that you want to go and pet too comfortably. That, okay, it's a monkey, fair enough. But sometimes the words that lawyers use are so blurred, you can't even distinguish between a blanket or a dog, for instance, okay? And it gets more and more confusing, all fiddling around with words. In this case, I'm just using images to get a feel for what it is that lawyers often do. And I repeat, I want to get back to basics in order to get to the future, okay? Because in the end, we don't want to end up just praying hard that the judge wakes up on the right side of the bed and gives you a decent outcome if you do go to litigation. Now, let's start from our emails that we're communicating. We're already in the present emails. What does the footer say? Observe the next time you see a footer in any of the emails that you receive, especially from the Attorney General's chambers and lawyers or whatever. How is it worded? This is my footer. Please don't print this email unless it's necessary. This helps and conserve the natural environment. It meant, it's in plain English. That's the message that I'm to drive at, not language which is in legook or legalese. Remember, the highest degree of professionalism requires altruism. What is altruism? Putting the clients and societies and your professional interests before self-interest. Okay, let's move on. I'm going to suggest some ideas which requires all of us here to have an open mind. So please keep an open mind for the next 9 minutes or so that I've got left. Now, okay, let's start with the basics. Reading law at universities, getting an academic degree, bachelor's, master's, PhD even, doesn't make you a professional. It doesn't make a lawyer a lawyer. But once you're admitted to a professional body, such as the Pune District Bar, for instance, then you're a professional. Likewise, my profession, quantity surveyor, project manager, charter builder, whatever, okay? And in my case, for instance, I've got a master's in construction law from King's College, but that doesn't make me a lawyer. I've just got an academic qualification in it. Yes, I might be doing an LLD, doctorate in law, after this, but that doesn't make me a professional. So what then is a professional? There's a minimum body of knowledge. Membership of a professional body would be expected, whether you're a doctor, a lawyer, an architect, engineer, quantity surveyor. You have a code of ethics that you abide by. And the fourth element, which is critically important, which is often forgotten by professionals, whether you're a doctor, lawyer, engineer, accountant, or whatever, and that is altruism. Prioritizing societal and professional interests before self-interest. Critically important, often forgotten. Let's move on. I now want to link the altruism to legal education in the 21st century. When we talk about legal education in the 21st century, just remember, we got to serve society, clients' interest before self-interest. If you're a gynae and somebody comes to you and you say, hey, look, let's go for a cesarean section because I make money out of it as a gynae. But if it's in the best interest of the client that they have a natural delivery, then that's what we should be recommending. I'm not going to make my money out of it. Maybe a midwife in New Zealand, it's only midwives who deliver babies, okay? But again, as a professional, you do what's in the best interest of your client and of course, society and your profession. And I'm going to use one or two case studies, specifically in my industry, which is the construction industry, which is heavily dispute prone. In fact, arbitration in many centers, a key area of arbitration disputes is always construction. Now let's take it to the next era. 21st century, when you talk about legal education in 20th century, in the area of law, the law of contracts, for instance, including construction contract, what is this thing? Smart contracts, smart contracts, smart contracts. So what are smart contracts? Smart contract is just like any other contract. It's legally binding, but it's got an additional feature in that it is automatable, either by machine, by computer, or partially with human input. So we need to bear that in mind as we educate lawyers or potential lawyers into the future. But the problem is the smart contract is developed by computer coding. Yes, we all know anyone who is Indian, of course, they're born with the gift of the ability to code. Okay. And apart from that, many of them choose to do law. They're also given the God-given natural talent to be able to speak well, which is brilliant. But the problem is not all lawyers can code and not all coders can do law. So, and when you deal with coding, it's binary, black or white. But the way the law is structured is a lot of gray. You must submit your notice within reasonable time, not necessarily always 5 days, 10 days, whatever. So there's a bit of a mismatch there, which we need to bridge the gap. Now, I say the way to bridge the gap is this. We should try as much as possible. We cannot avoid the gray in law because reasonable time, for instance, is a concept which is acceptable in law. However, what is not acceptable, and here comes the key message in my session today, and that is if we can avoid legalese, legal jargon, which is unnecessary, which is redundant, we will do a big service towards moving towards helping coders, people who do coding, and start developing more effective smart contracts. That is my message. And here now is a series of examples of clauses from existing construction contracts, as I said, as an example, but other contracts are equally bad. Here is a clause from Singapore, and I look at it worldwide. I've also got the Indian contract, which I bought when I was in Delhi, Pune, Hyderabad, Chennai, and so on my trip in 2019 with the university, looking at collaboration with universities in India, including IIT in Chennai, IIT in Delhi, and so on, which was a really interesting session. But here is an example of a clause from a Singapore contract. The words are so convoluted. And here's another one, also from the same contract, 147 words in 2 sentences. I'm from the construction industry. I'm a quantity surveyor. I administer these contracts, but I struggle to understand this. You go to the UK, same story, 156 words in 1 sentence. My students don't understand it. I don't understand it on first reading. And I find many lawyers don't understand these sort of legalese, or in an extreme, they're called legobblegook. Or even this, okay, 159 words in 1 sentence. This has to go because just like dinosaurs, they belong in the museum. They're extinct. And it's time we got rid of legalese. Why? Because legalese doesn't serve our society, our clients, lawyers' clients. It doesn't serve them. Then the next question is a series of questions to ponder. Okay, Naseem, you're saying about plain language. What do you mean by plain language? What does it mean? Whose legal drafting guidelines are we going to use? Is it possible to write contracts without losing the legal intent? What are the benefits? Has it been done before? These are valid questions. I'll deal with it very quickly. What is plain language? Whose model drafting guidelines are we going to use? The answer is, I don't care which drafting guidelines you use from anywhere in the world. Here is one example from the Australian government. You can copy it. It's not copyrighted. So if India wants to develop something where the Indian government says, hey, look, we got to draft contracts or communication in plain language, just copy it. In the US, there's a Plain Language Act 2010. In New Zealand, there's a plain language bill in Parliament right now, which I'm strongly supporting. Okay, so there are many, many, many examples of non-legal drafting guidelines from legislation, from community communication, and so on. Plenty, and I'm just giving some examples. Okay, next question: is it possible to write contracts in plain language without losing the legal intent? The answer is absolutely yes. If you look at the banking sector, insurance, health, even taxation laws have been rewritten in many countries. Even the so-called complex construction industry, we've done it. Okay, what is the benefit? I cannot be listing. This is not the topic for me to explain the benefits of it. I'll just quote Professor Peter Butt from Sydney Law School, which is one of the prominent law schools in Australia. And he says, the evidence is unequivocal and overwhelming. Has it been done before? Has it been done in the construction industry? The answer is yes. Here is a link to a contract, which is the first construction contract in the world to get the Clear English Standard accreditation from the Plain Language Commission UK. I've attached a link to everyone, and feel free to download it. It's free anyway. Well, I wrote it, and I insisted that I want this to be shared with the world. I do not want copyright restrictions on this. Okay, so you can have a look at it. And here's just some extract from and a contrast to other contracts in the world where they've got 81 clauses, for instance, and it's just simple word. All instructions must be in writing. Contractor must start on the date stated. Really simple. There's pro forma templates as well. Certify was achieved on. No whereas, no herein before, no words like and stroke or, no redundant doublets like null and void, no Latin phrases, no multiple cross-referencing, average words per sentence of 20 words, like what Lord Denning would write, and so on. Okay, so now the question is, I'm not a lawyer, am I? I drafted that contract. Yes, there was a full committee, including lawyers who were involved in it. But what do world authorities have to say about that contract? Joseph Kimball rewrote the court procedures in the US. He said, great effort, pretty good. Professor Peter Budd, emeritus professor, law professor, Sydney Law School, he says, a marvelous document. Judge Mark Painter, one of the most published judges in the state of Ohio, who then went on to become the United Nations Court of Appeal judge, he said, looks good. All plain language principles were followed. Okay, and Mark Adler in the UK. The reason for that variety is just so around the world, they thought it's possible. Now, it might look simple, but behind the scenes, there's complexity. And here's an example of a before and after, how you rewrite clauses, and invariably the contract becomes shorter. Even the word shall, most lawyers think it means must. Yes, indeed, it does mean must. But unknown to most lawyers, it can also mean the discretionary may. And it's at least 8 other meanings. Who said that? I say it from reading a clause, for instance, this one from the New Zealand. Plain reading means must. In this case, it means may. In this case, there's a third meaning of may. And guess what? That's just my reading of it. Who am I? I'm not a lawyer. I'm not a judge. I'm not an authority. But let's see what world authorities have said. Brian Garner doesn't just write books. He writes dictionaries. His dictionary in modern legal drafting, pages and pages on the word of the use of the word shall. He says, don't use it. Professor Peter Budd identifies 8 meanings of shall. Surely that goes against the basic rule of golden rule of drafting. One word, many meanings, best to be avoided. So in my industry, for instance, quantity surveyors often write, architects often write, oh, work must be strictly in accordance with the drawings. Just a bit of humor. Architects would draw those little clouding and so on, and the contractor built it with the numbers embedded on the staircase. Well, they shouldn't, but it's just a joke, okay? And clouding to show the changes, and the contractor thought, oh, that means there's a hole in the gap. So, interpretation of contracts. Anyway, to cut long story short, to shall or not to shall should no longer be the question, just shun shall, don't use it. And I've got an example of another contract, a consultancy contract. Earlier was a construction contract. This is a consultancy contract. Published in New Zealand. Again, myself and my students drafted that. And just to demonstrate that it can be done across in many, many areas. Now, evidence shows, this is to keep academics happy, that research shows judges and lawyers prefer plain language. Now, then the question is, how do you do it? Answer, look what Rudolf Flash says. By the way, Rudolf Flash, in case you didn't know, on Microsoft Word, you can look at the Flash Reading Ease Index, which gives you how well you've written from a plain language perspective. He says you have to study it, just like you want to study Spanish or Hindi or Urdu or Tamil or whatever. Luckily, I speak Tamil, but I don't write Tamil. I studied Hindi for 3 months, thora malum hai, but not so much now. Okay, I speak Malay and English and so on, but you got to study it like a language. Now, going forward in the 21st century, contracts have been represented in flowchart. Because construction contracts, for instance, engineers are looking at it. They love flowcharts. They don't like words. Now, one more thing, I want to appeal to your emotions as a lawyer or as or those involved in legal education. This here is the extent of trust amongst various so-called professions. Firefighters are right at the top of the heap and lawyers are at the bottom of the heap. But just like you can twist and turn statistics, what is encouraging is over the 5 years between 2010 and 2015, lawyers' extent of trust has increased the most by 34%, but lawyers are still at the bottom of the heap. People just don't trust them. How sad. Surely there has to be something done. This is a typical contract. Kriska, subject always to clause 14, and you go to clause 14, subject always to clause 32, and you go to 32. That's not the way. Okay, this is an example of multiple. I gave examples earlier, right? Now, even the use of the N stroke or have you seen? Has anyone seen the use of N stroke or in contracts and so on? Is that common? I'm sure it is common throughout the world. But what have judges said about it? Abominable invention, inexcusable barbarism, verbal monstrosity, the child of the brain of someone too lazy or too dull to express its precise meaning. This is criticism from judgments. And what do? We still ignore it. Now the question is there a solution? There is a solution. I can share these slides with you so you can look at the solution to an alternative of N stroke or A and or B and or B. All you have to do is a combination of one of the more of the following. And I give you more examples before and after. You can see immediately how much shorter it is without losing the legal intent. Now, in summary then, if you really were looking at drafting a contract, what are the guidelines? Here are my guidelines, which I've picked. I picked 16. I can share with you the slides, but basically it is average words per sentence of about 20. If you look at Obama's speeches, average words per sentence about 16. Lord Denning's writing style would probably be about 14 words or so. Gender neutral language. Active words are preferable. Plain words over complex words. Fewer syllables. Don't say, I'm going to utilize this phone. No. Just say, I'm going to use this phone. Stop using multisyllable words when you have an alternative, which is in doublet redundant, like null and void. That's redundant. 14 bracket 14 days. Why? It's redundant. Whereas said redundant. Multiple cross-referencing, excessive definition. Terms of art, of course, must be maintained. Reason, skill, and care must be maintained. Fitness, purpose must be maintained in my industry anyway. Okay, and so on. Anyway, I'm now wanting to finish off with just a few words of looking at the future. Okay, now I have come up with some sort of a formula. My hypothesis at the moment is the possibility of error in a contract is directly proportionate to the number of words M multiplied by the complexity of each word squared. So mathematically, E equals MC squared. I'm no Einstein. This is just my hypothesis, which I'm doing a bit of research on, as to the future of construction contracts, which is my area really. And I'm hoping that by 2030, which is a 10-year vision, all construction contracts in the world will be rewritten in plain language, including the one from India that I've got a copy of. Now, a word of warning. Christopher Bamford wrote in Australia, today commercial clients of Australian law firms are prepared to pay for legal services that are plain. One day, clients will refuse to pay unless they're in plain language. It's a wake-up call. Finally now, I want to go back to the 4 words that I started. Law, peace, legal education, 21st century. Law is what this conference is about. Peace is to avoid disputes. Let's not have court cases arguing about words and semantics when we could easily write it in plain English, day-to-day language, and avoid peripheral arguments. Legal education, my key one message is, I think it is time to up the ante and to teach law students in something, this new language called plain English or plain legal language. Not necessarily, I don't mean English, but plain legal language, whether it's plain legal Hindi or plain legal English or whatever, okay? And remember, as we move towards the 21st century smart contracts, without the contracts being written in plain language, the person who is doing the coding, I'm sorry, you're going to get contracts which are convoluted, and therefore the smart contracts are not going to be brilliant. And remember the word altruism. Clients, societies, and your professional interest comes before self-interest. Okay, so serve the client better by writing in plain language. My personal vision is just that what I'm sharing. All construction contracts in the world to be rewritten in plain language. Now, so just remember altruism, clients and society's interest before self-interest. If you do communicate in plain language, you will be serving your society. Now, final 3 slides. This cow looks like a perfect cow, but no cow is perfect. New Zealand can't It's not visible on that cow. If you look at the world map embedded on the cow, but New Zealand, so look, we just try to improve ourselves, but we will never reach perfection. Finally, do you want me to ask you questions like this? Notwithstanding the fact that you may have experienced a similar to intellectual comprehend all that I may have said or uttered in express terms by illustration, analogy, or whatever on the 17th Gregorian calendar day of this. Is it how I should be talking? Or should I just say, if you've got any questions, you can ask me? I prefer the plain language version. Thank you for inviting me again to all the organizers, there's strings of them, eminent professionals, professors and authorities and so on. I thank you very much for this opportunity. I hope I've shared some ray of an idea about education as we move towards the 21st century. Thank you very much.
Thank you, Dr. Naseem, for your valuable inputs and thoughts. Now, I would like to invite Dr. Priyanka to share her thoughts on legal education.
Good afternoon, everyone. Am I audible?
Yes, you are.
Okay, thank you. Actually, I'm thankful to the MIT WPU University and the organizing committee. And more than that, I'm thankful to the earlier two, both the speakers, Sangeeta Laha ma'am and Naseem sir. Already they have made a very good platform for my further discussion. I'm going to talk about the legal education in the 21st century and the role of peace in the lawmaking process, or how law is helpful in the peace building activities. So before, as both the speakers, Sangeeta ma'am already spoke about the how legal education and the actual scenario of legal education in India, and how our university structures work, how curricular are framed, how research and teaching activities are getting merged with each other. Earlier, we don't have this kind of luxury to the legal education, but now students have this first preference in their career option, that many students want to become law professionals. It's not only about the lawyer or there is not only the options of becoming judicial officers or lawyers particularly, but there are at present ample of opportunities available, from corporate to a number of activities which you can do after having good legal education or law degree, we can say. Since almost the first word for the National Law University, or we should have a educational institute particularly dedicated to legal education, this kind of a thought was first introduced in 1964 and all. After that, Professor Upendra Bakshi, then Madhva Menon, they literally filed reports to the government and did pursue. But ultimately, whole that process almost took more than 30 years to the establishment of first national law school in India. But now, when we see across the globe, as well as particularly talking about the Indian legal education system, we have national law schools, we have state universities, and we have very good private universities like MIT WPU and other private institutes around the country. But there are different understandings about the career options or career opportunities we get after getting pass out from such institute, which is actually not true. You can get a legal education from any of the institute, whether it's a private or state university or a national law university. Ultimately, how you invested your time during your whole law journey, that plays very important role. So today I'm going to already both the speakers have set the ground for me. So I won't repeat the points which I wanted to discuss, but here I would like to highlight one. There was one survey conducted by the American think tank, and they worked on the advancement on legal system and advancements in the legal education. So as per that report of IAALS, they come out with the survey in the American legal system prior to the COVID-19. So out of the 100% population from that survey, they interviewed three particular category of, we can say, one was the practitioner, another was the legal professors, law professors from the university, and the third was the students. and they conducted a survey to understand how legal education is contributing and what are the shortfalls between the actual needs of the society and how we are preparing our students to become good lawyers. So after the third year or the fifth year law school, out of the 100, there were 70% of the students who believed that they are having sufficient skills to practice immediately in the court of law or can join hands with the legal practitioners. Contrary, the professors who taught them, so take for example, out of 100, there were 71% students believe that they have apt skills. But when the survey analysis showed that the law professors believe that only 45% of the law graduates have sufficient skills to practice immediately after getting passed out. When we see the responses from the practitioners or senior advocates under whom these new law graduates go and join, or the corporate offices where these new law graduates go and join, so the survey reflected that these practitioners believed that only 23% out of whole lot of new law graduates, only 23% had the sufficient skills to practice. So there is a huge gap, that the expectations of the practitioners is different, and the expectations of the law professors is different, and the students they believe that okay, yes, they do have so much knowledge. The reason behind that, they invested their lives 5 or 3 years into the course, invested some, they paid some fees, and then did 2-3 more diploma courses and internships and all that thing. But ultimately, when you go to the reality or you go to the actual field, there is so much difference into the reality and what you have learned into the textbooks. So today, while talking on this platform about the legal education in the 21st century, I would like to highlight that our curriculum, our degrees should not be in such a way that it is the thought was since the independence era that the curriculum was framed in such a manner and all that. Today, in the globalized world, our demands are different, our requirements are different, and the challenges and opportunities are altogether different. When we talk about the practitioners and the expectations of the clients, as Nasim sir has rightly pointed out about the construction contract, he was talking mainly about the drafting skills of the lawyer. Here, I would like to point out about the expectations of the client. So in today's world, when our clients are expecting lawyers to understand their business, today's our educational institute, we need the leadership which can understand what are going to be challenges for the future. We can't teach them the age-old law. We can give different interpretation to the old legal principles and the what the old principles which we do have, or legal theories which we do have. But the challenges in today's society are altogether different, and we have to relate it with the today's opportunities. Today, client wants their lawyer to understand the basic functionalities of the area. For example, I would like to give name the domains like cyber, science and technology, medical, particularly air and space law. So when we talk about air and space law, as you can see, there is so much boom in the space industry. There is privatization, then space tourism is coming out. I'm working on the use of nuclear energy in outer space exploration and its law and policy matter. So you can't go and particularly find out a particular law syllabus where you can learn these things. You have to go to different subjects, and then you have to collect the understanding and then come up with the solutions for the today's problem. You have to come up, and then you have to find out what should be the regulation, what should laws we should have, which will address the unseen problems of the society, right? We can't relate the same contract principles or the same loopholes or same criminal justice principles to the take example of the sexual harassment at the workplace. If we are talking about the concept or the legal protection which is available under this kind of issues, what is the how we can relate this area with the online platform? Are we going to just again go back to IPC and IT Act and all that? But the problems are going to change, and likewise, it's the educational institute who have to make our students well equipped with the changing dimensions. And when I say that client expect their lawyers to understand the basic functionality of their business, so this will help in for the client that these legal service providers are not like ordinary legal service providers, but they are more refined. They understand the business requirements. They are more creative. They are more innovative. They are sound with the help of a technology, and they do have values and ethics. We can't always just go behind the technology, but at the same time, we have to stick to the values as well. And better than law and justice system, nobody can work well on that front. When the lawyers are able to understand the basic business needs, they will avoid unnecessary and unexpected litigation for the client. So it's always better to make our students more equipped with what are the future trends, what are the current trends. If we talk about India particularly, there was a time when we pass out from our, I'm a product of ILS Law College, and then I studied with the Department of Law, Pune University. I did my PhD in nuclear energy laws as well. So that was the time when people used to say that artificial intelligence or AI won't come into the legal system or in a legal market. But if we see today, many AI applications are used for the legal research, even teaching, and many legal service providers are taking help for not only for documentation and other research tools, the help of AI or the technology, but they are also using it for making their job more easy. So we have to make our students more worthy. We have to invest into the capacity building of our students, where they are able to cope up with the today's changing world of a technology and able to relate the same legal principle with the new advanced technologies and the advanced challenges. We don't want to make our students with the regular ordinary law or service providers. So when we talk about the what are the solutions, I think the first one is the collaboration. We must have the interdisciplinary collaboration. Like MIT WPU has a variety of branches like MBA and management and law and then engineering. If we can collaborate with the multidimensional or interdisciplinary field, that will helpful for the students, not only for understanding of basic legal nature, but it will also help them to groom overall development of a student. Also, in today's world, everybody is expecting quality legal education, and with the upcoming new education policy is also there. So with that help, we can always think for the interdisciplinary collaboration. Also, we have to focus on industry and field exposure, where students can start learning not only about the internship of few months, but like how medical education provide opportunity to their students, so that they are immediately able to serve the society. We also need to think something from that particular aspect, that we have to train our law students that even though immediately if they join the industry, they are able to fulfill the needs of their employer. As at present, if we see, not a single government institute or a corporate who appoint their legal advisor or they select even after placement, every company invest into the training of their particular cadre of a student. So even if company is also investing in training of the particular legal law students or the any student, then what's the use? We are investing twice on the same product. So it's the job of the educational institute that we should make law student industry ready. Also, lawyers are the leaders and they are the influencer if we see the history. So it's our responsibility to be more and more aware about the today's challenges and opportunity. And students need to have different skill set and rather than the routine activity. Particularly talking about the law and treaty
I think there's some technical glitch.
Am I audible?
Yes, ma'am, now you are.
Okay. As our moderator was asking about the law and treaty division, so when we talk about the policy framing and the drafting of the particular bilateral or multilateral agreement, see, every time the colleges, this I want to share with the students, you also need to be proactive. You have to find out work for yourself. You have to come up with the interest area of your own, because every one of us is unique, right? So if I like drawing, somebody likes theater. So you have to come up with that your profession, how you're going to connect with your choice of activity or your hobby, that what kind of legal issues might be there. So you have to come up with certain innovative ideas to find out solution. When we talk about the policy drafting and policy framing, there are always opportunity given in the from the government of India. There are always, when bills are debated in the parliament, they also ask comments from the public. So I think it's the job of a teacher, educational institute, as well as a student, to discuss on the drafting side of that, those policy drafting side of the act and regulations and rules, so that our students will be able to understand the philosophy behind those particular sections, those behind those particular articles and all that. uh, Even I'm convinced with the Sangeeta Laha ma'am, who talked about the PhD and the research in the Indian legal system and overall, as it's made compulsory that you have to have a PhD, otherwise you won't get uh, assurance in the services. But because of this, the research quality is getting diluted. At Pune University also started with the postdoctoral fellowship, but the basic intent was to have it a compulsory research program, so that people should not treat it like any random research degree. So likewise, we have to think on how we are providing our students, how we are providing to the society good product for the who will able to serve them. When we talk about peace not start only, it's not only about the absence of violence. When we talk about peace, and especially when we talk about peace at the MIT WPU, it should have a wider understanding under the leadership of Dr. Vishwanath Karat. It's the responsibility to this law school that you already have a very rich culture and a rich heritage. So the law school expectations from this law school and this student is much more. There are many national law schools which are branded to be producing corporate lawyers. There are few few law schools. They are proud to produce more judicial officers. But I think I wish MIT WPU that with this law school, they should come up with the peace lawyers, or who can contribute to the society, who can contribute to the, or who can become the lawyers for the society, for the social cause, and not only serve to the big corporate houses, right? So with this, I would like to have more questions rather than just sharing my thoughts. Yes, I think I should wind up. Over to you, moderator.
Thank you, Dr. Priyanka, for your valuable inputs. Now I'd like to invite Mr. Utkarsh Misra to share his thought on the legal education.
Am I audible?
Yes, you are.
Good afternoon, everyone. And first of all, I think it's my pleasure to be introduced by Professor Manoj, because he was one of my teachers at NLU Jodhpur. I don't know, sir, if you remember me or not, but
Of course, I remember you.
So this is such a small word, and I couldn't meet you physically, but see, this is such a nice way to interact and meet. And it's my pleasure to be invited here and speak to all the students who are watching this session. I must also congratulate the organizers who have actually thought that there can be a session on legal education in 21st century. Having heard the previous sessions by the learned speakers, I would like to focus on some very critical points of understanding for a student of law, which he or she must imbibe in herself or himself while getting educated, in law. See, when you see this very expression, legal education, I think as a student, I still count myself as a student. And even after I have come to Supreme Court on this deputation, I still see that, law is something that you cannot be very static about. And it's the knowledge of law is not at all static. It keeps on changing every day. So you have to keep yourself updating. So even here in this institution, the apex judicial organ of the country, every day we struggle with lot of files and lot of research works, and we do a lot of research here. So I somehow relate the idea of legal education with research a lot, because nowadays education itself, especially legal education, has become more and more research based. If you have to talk about education, generally what comes to our mind? Generally, there are few questions like, what do we read? What do we write? And what do we research? And as a student of law, reading, writing, and researching become the paramount parameters to decide your success in legal education. And this is the context in which I would like to speak to all the students who are watching this session today, that when you talk about legal education and when you talk about studying law, what is most important, according to me, is the literature that you choose for your reading. And when I say literature, I do not necessarily refer to the standard books which are available in the market or on the online platforms or online web resources, etc. When I talk about literature, I mean everything which surrounds us. If you, I don't know how many of you, I'm just talking to students right now. So I don't know how many of the students watch some very good movies, but I think if you watch some of the very good movies, you will get some very good perspective beyond what is obvious. Nowadays, as I said, because legal education is more and more research based, things are going beyond what is more obvious. It's not just that you can read some bare acts. You can just read Constitution of India. You can read lot of other legislations, and then you can say, oh, I have become legally educated, or I have become educated in the realm of law. Nowadays, in 21st century, you see law is not seen in isolation. It is seen in connection with society, economy, and polity, all three of them. So that is why there are cross-cutting areas also. So you see, even though you might be reading in your basic curriculum of LLB honors some very basic papers like Indian Contract Act, CRPC, CPC, Constitution, and so on and so forth. But you see, nowadays, universities have also started to offer some very good optional elective courses like critical criminal law, critical contract law. Then there is international business law. There are mergers and acquisitions. So there are different papers. Law and society is also taught as a separate paper in the form of an elective in many institutions, in the form of elective courses in LLB program. So why I'm stating all of this is that now you cannot say that you have read Indian Contract Act 1872 and your knowledge of contract law is complete. No. This is one message I would like to give to all the students watching this session, that even if you're reading contract law, you have to look beyond the act. You have to actually read the agreements, the practical agreements, the way they are drafted, what negotiations go between the parties on the discussion table, what are the social factors which influence a contractual negotiation. That is also important. Now, the reason why I talked about movies is that I don't know if you have watched a movie called Shawshank Redemption. I don't know how many of you have watched it, but this is a movie wherein a person is falsely accused of murdering his own wife. And obviously he's falsely accused. And then he's sent to prison for a very long period of time. Now, if you see this movie at a very outset, from a very isolated point of view, you will see, yes, there was a crime committed and the person has been sent to jail. But if you see the movie in its actual form, you will find out that inside the jail, lot goes on, which is nothing but the sheer violation of human rights of the prisoners. Even after a prisoner is released on parole or otherwise, the person is not able to rehabilitate in the society. So ultimately, this is the domain of legislature. This is the domain of policymakers, because nowadays it is not only our concern, or it should not be the concern of policy makers, that you just find the culprits, send them to prison, and your job is done. So since we are reading a lot, we are debating a lot, we are talking about reformative theory of punishment, we are talking about rehabilitation of individuals, because now we have started to respect something known as life. Now there is a debate going on, already all across the world, that death penalty should be abolished. Why? Because the meaning which has been attached to life has gained immense importance. So even if a person who is sent to the prison, and once he comes out of the prison, he is a live person. He has to be treated in a particular way. And then the state has to have certain policies for that particular person so that he can rehabilitate, he can join back the society and not become a criminal, so to say, once again. So what I mean to say is that when you choose your literature in reading of law, your literature should not be restricted to only your books, articles, which are available offline and online. Nowadays, because of lot of developments in the legal theory, as I mentioned, you see a lot of cross-cutting disciplines emerging, just like I said, critical criminal law. You will always be able to find other sorts of postmodernist literature as well, which you can say critical legal literature. That particular source can be available in the form of a poetry also. That particular source can be found in the form of a prose which has been published in a newspaper. So when you read as law students, I think you should broaden your horizons to also look into those literature and then derive for yourself some ideas. Why do we keep on debating about citizenship? Why do we keep on debating about immigration crisis in India? NCR registers and then detention camps in Assam. The reason is nowadays individual stories have started to be heard. Earlier, it was more, the legal education was more community based, in the sense that it used to look into the society as a class of people, and then it used to regulate that society as a whole. And then there was a legislation for a society as a whole. But nowadays, if you see, a society has been very fragmented in different sections of the society, into the different sections of the society, and every section has a different concern. So, things like Transgenders Act. Now, this is a very, you can say that it's the marker of the modern legal education of 21st century, that we are able to have a legislation in place for a particular section of the society. Now, the same is required on the part of law students as well. So when you read a particular law, you should not read it in isolation of its social, political, or economic factors. You have to have the idea of what goes beyond. And that, in way, will help you to develop your own area of specialization. I think our last honorable speaker from the Ministry of External Affairs was speaking about how to make students industry friendly. Now, this is also one of the way when you can become industry friendly, is to involve yourself in more and more sort of, I will say, multidisciplinary or interdisciplinary research. So if you write an article today, it should not be restricted to just one legislation. If you're focusing on the critical analysis of that legislation, it should go beyond that legislation, because knowledge is no more static now. Similarly, I must put focus on, I had made certain points for the law students, And another point which comes to my mind is about the usage of IT tools. It's becoming very important nowadays, because if you see, because of the COVID also, we are doing the legal education in online mode. And it's not just about this particular period when COVID is going to last. It's going to be the future. So you must be able to actually utilize these skills, especially the IT tools, which are available for free also, and some are available by way of subscription through your institution. A student should be very friendly with those IT tools. Why? Because the reason is, nowadays legal education is not restricted to whatever your teacher says in class and whatever you just mug up. It is self-paced now. It is self-paced, which means that even if a certain debate is happening in the class, and if you want to actually reflect upon that debate and upon that particular issue, you will have to start using you have to start learning to use lot of these IT tools as well, because nowadays they are door to lot of those multi purpose sources which I was talking about. So when I say literature, I actually say literature which includes books, it includes your online material, it may also include some different sort of literature available, like movies, poetry, newspaper articles, etc. Secondly, the next point that I would like to make here is that which many of the institutions today in India have started to focus upon is going back to your own roots. India is rich in culture. I think all of us know that. And somehow we have not been able to utilize the fruits of our own ancient scriptures, which nowadays have started to become very relevant. So going back to Dharma Shastras, going back to Vedas, going back to the original literature should be also one of your top priorities when you study something. Because it's more, legal education today is not more about what or how or when. It's more about why. It's more about questioning. And when you are able to question a particular thing, and if you know how to answer that question, you will be always be able to find solutions to that question. In order to be asking the right question, you will have to locate right resources or right sources, so that you get a right literature for the purpose of your research. So history, conceptual history, all of that becomes very relevant in 21st century. The way man and women and were interpreted 20 years back, 2 decades back, I think that interpretation has changed a lot. The way gender restrictions have been interpreted now, that has changed a lot. This is all because of history. So as a student of law, I would really press upon to all of you that you must concern yourself with reading these interdisciplinary sources as well, so that you can be more informed about it. Another point is that if you want yourself to be very competent enough in placing yourself somewhere in the current legal education, you have to have a set of 3 skills which as a student of law one must have. One thing is that you have to do an immense reading, because as I said, your sources today are not just your bare acts or your commentaries. They are more than that, because legal education today is not much objective. There is a lot of subjectivity creeped up in the legal education, which is for good also. So when you talk about Nirbhaya rape case, if you are being objective, you can only say that, yes, okay, these were the culprits, and they must be sentenced to death, etc., etc. But having introduced some of the subjective notions into that Nirbhaya rape case, the situation, you will be able to find that lot goes inside when the investigation happens. What problems do police officials face when investigations happen? What problems does prosecution face when the prosecution happens? So an event has to be fragmented further by a law student. It should not be seen as a whole. I would propose this in the session, that an event should not be seen as a whole, but it should be rather fragmented into pieces and then individually inquired about. And that will help you actually gain a lot of knowledge and, in fact, a lot of edge over other argumentators. So you have to have a set of new skills, that is immense reading. Secondly, creative writing is also very important in the modern legal education, because I think that informs the reader about your understanding of how you are able to receive a particular law or the issues related to that law. So your writing skills are very important in the current legal education. And the reason is, again, subjectivity. And obviously, lastly, I said good research. If you are able to expertise yourself in research techniques, tools, then half of your job is done. Because as a law student, I'm sure that you will share this thought with me, most of the students who are watching this, that in first and second year, you require a teacher to tell you something. You definitely require a teacher to tell you what to read and what not to read. But by third and fourth year, you start to read on your own, because you understand what is important and what should be important. So your research skills play the most important role in the legal education in 21st century. And that is the whole idea behind my talk today. So lastly, I think I'll sum up my presentation by giving these points. I've also crossed my time limit, I believe. If you have any questions, I'm open to all the questions. But the major point that I would like to impress upon is, once again, this, that nowadays institutions should focus more on enriching the research skills of their students, because even teachers cannot teach everything in the class. That's a reality. And I think most of the honorable speakers do share this thought with me. So if you have to make it actually successful, if you have to call yourself a successful teacher and the other student as a successful student, you teach the student a good research skill. The student will himself or herself equip themselves with those skills and read and come to the classes. So I think that's it. Thank you so much. Thank you.
Thank you, Mr. Utkarsh, for your valuable thoughts. Now I'd like to invite Mr. Sylvester. I think he just joined us on the panel. So if you can hear us, Mr. Sylvester. Shanika, he's there on the panel?
Yes, sir, he's there. Mr. Sylvester, could you please unmute yourself? So he's there on the panel, but I think maybe due to some technical glitch on his part, he's unable to unmute himself. So by the time sir joins us, why don't we engage the session with some interesting questions that some of the students have asked, with your permission?
Yes, of course, they can ask. They can ask directly from the speakers or any panelist.
Yes, so the first question is from a third year BBLLB honors student, Janvi Shirode, and the question is for Dr. Sangeeta Laha, ma'am.
Yeah, yes.
Greetings to one and all. Thank you for this opportunity. Ma'am, my question is, will the incorporation of moral education in law school help in making a better lawyer?
Yes, that's a very good question from a young budding lawyer. Yes, moral does plays a part, but in professional ethics, we have a subject as professional ethics. As you will go into senior classes, in professional ethics, lot of code of conduct is taught, but that is just a classroom teaching, I believe. The code of conduct, when you enter into the practical life as a lawyer, you have to build yourself with it. The first thing I've noticed, In criminal practice, there is one word which you have come across, tout, T-O-U-T, tout. So many criminal lawyers base their practice on tout practice, that is unethical. So this you won't get in classroom teaching or in a subject of professional ethics. That you have to fight your way through. And once you develop yourself, once you make a mark as a good lawyer, a sound lawyer, I'm sure Pune Bar must be having very good sound lawyers with good ethics. You make a mark of you. So that first 5 years of your practices, you have to tempt yourself. No money, no work. Some work, no money. Some money, some work, and then money and money. So that phase every lawyer crosses through. But yes, moral teaching is something which a teacher or a court's infrastructure one cannot be taught into. It is something that you develop in your practical. Thank you. I hope I've satisfied you.
Yes, ma'am. Thank you.
Okay, I think still Mr. Sylvester is unable to unmute himself. So we'll utilize the time and we'll take up the next question.
We can continue with the questions.
Yes, sir. The next question is from Ira Lagu, and the question is for Dr. Naseem Amir Ali.
Greetings to everyone present here. Thank you so much for this opportunity. So, sir, my question is, over the period of time, how has legal education system helped in gaining knowledge beyond the classroom and in making better lawyers?
Okay, that's a general question. I'll just respond to that. One of it is, I think the other speakers have addressed many of those issues, but one of the things that I personally find as a non-lawyer, remember I'm not a lawyer, but within the construction industry is this. The construction industry is dispute prone, and often the dispute end up in arbitration or adjudication or mediation, but it also goes to court. Now, the one thing I've found is that when you're a multidisciplinarian, as opposed to a pure lawyer, they tend to be specialized and they tend to do better because it becomes more efficient, especially in arbitration, for instance, because there are a lot of technical issues and so on. They tend to be better. But that doesn't mean that as a lawyer, you can't deal with technical issues. Absolutely, you can. And I've seen good lawyers who, after practicing in law in a particular area, then they specialize. And sometimes to do that, they may well do a specialist program like in master's or PhD or whatever. So that would be one way. But don't forget, whatever it is that you choose to do, try and communicate in language that your audience understand.
Ira, I hope that satisfies your query.
Yes, sir. Yes, sir. Thank you, sir.
Okay, the next question is from Vanshika Gupta, and the question is for Mr. Utkarsh Mishra.
Good morning, everyone. Good afternoon, everyone. My question is for Mr. Utkarsh Mishra. How to overcome...
Can you be a little louder, please? Your voice is not audible.
Hello, am I audible now?
Yeah, better.
So the question is how to overcome the problem of outdated syllabus because of the focus on traditional and basic subjects.
No, actually, I do not believe that there is something called outdated syllabus. See, there are certain subjects which are traditional and which have to be taught because they are basics. For example, you study law of tort, law of contract in your very beginning semesters. And as I said in my presentation also, you cannot be totally, ignorant of the roots. You cannot be totally ignorant of the developments and the history. So it's up to you. It's actually obviously the concerned faculty or the concerned teacher also has to look into this particular issue as to how to make the syllabus more interesting. So there's nothing called an outdated syllabus. It's just that a syllabus can be made more interesting as per the requirements of the time. And as a student, what you can do is, for example, if you are reading a Consumer Protection Act, maybe as a part of your tort law studies or something like that, you can be more involved in reading more issues, cross-cutting issues in relation to consumer protection. For example, why medical negligence is not part of Consumer Protection Act anymore. Just a small example I'm giving you. So it's up to both the student and teacher on as to how to make your syllabus more interesting. So there is nothing called an outdated syllabus. There will always be some traditional subjects in your beginning semesters because they form the very fulcrum of the entire edifice of your education. Okay, they are basics, they have to be taught, but it doesn't mean that they are taught in a very outdated fashion. That is a different thing. So if your teacher herself or himself is outdated in her knowledge, that is a problem. But syllabus, I think that can be, it's up to the student teacher interaction.
Thank you, sir. Thank you so much. In the meantime, Mr. Sylvester has joined us. Sir, can you hear us? Sir, can you hear us, Mr. Sylvester?
Ask him to unmute. Yes.
Good afternoon.
Good afternoon, sir. So we are eagerly waiting to hear from you, but a humble request, please restrict to the time limit of 10 minutes so that we can end the session on time. Over to you, sir.
Please come again, pardon, please.
Yeah, sir, please help us to end the session on time by restricting yourself to the 10 minutes time span.
Now, good afternoon, gentlemen and ladies. Thank you very much for inviting me to speak at this wonderful event. I feel honored to be with you on this program. I'm invited to speak on the challenges and prospects of legal education in the 21st century. The time is limited for me to speak. I will try and just touch on the major things that should be noted about the legal education in the 21st century. Now, the outline for my presentation, unfortunately, I'm not a host, I'm not able to share the slide, is number one, what is education itself? And then what is legal education? Features of legal education, objectives of legal education, and what is legal education itself? What are the basic characteristics of legal education in the 21st century? And then what are the challenges legal education faces in this century? What are the solutions and what are the prospects before us? Then the paper also comes with conclusion and some recommendations are made for which, if considered, I believe would assist in sustaining the gains recorded by legal education and then moving us to the next level. Now, from the paper, the main paper discusses that education is itself the process of receiving or giving systematic instruction, especially at a school or university. It is concerned, education is a discipline. Education is a branch of knowledge, it's a discipline concerned with methods of teaching and learning in schools or school-like environments, as opposed to various non-formal and informal means of socialization. This is the explanation or the definition given by Encyclopedia Britannica. Some people have also described education as transmission of the values and the accumulated knowledge of a society from generation to generation. And education, but the most important is that education brings about an inherent and permanent change in a person's thinking and capacity to do things. So the object of education is to change permanently the way a person thinks and his capacity, to enrich his capacity. For example, in the aspect of law, if you acquire legal education, for example, you cease being a layman and you acquire some skills and knowledge and values in the area of the legal profession to enable you perform some of the roles or all of the roles a lawyer performs or the functions a lawyer fulfills in society. Now, that takes us to meaning of legal education. What is legal education? Legal education is the education of individuals in the principles, practices, and theory of law. The purpose of legal education is to equip you with skills and values and ethics to practice law. But we must note at this point that practice of law is not limited to litigation in the courtroom or solicitorship outside the courtroom. There are various things, various opportunities a lawyer can fit into the moment he has acquired legal education. But legal education serves society liberally by imparting general and cultural education to law students, or the people we refer to in Nigeria as aspirants to the bar, making them good and law-abiding citizens. That's the first thing. And then they will now have some skills and training, specialized training instilled in them. And those skills instilled in them must be relevant to democratic society. That is, so the legal education in Nigerian environment is geared towards inculcating skills, values, and ethics in the aspirants to the bar to enable them cope in their chosen career, should they choose any of the various options that are available to a lawyer in Nigeria, for example. We have various forms of legal education all over the world. Generally speaking, we have primary degrees in law. So that's the one form of legal education is aimed at acquiring a degree. This type of education is usually seen at the undergraduate and the graduate level. Undergraduate level is just to acquire a degree in law. Then we also have other degrees like LLM, PhD, which is also referred to in some jurisdictions as JSD, and so on and so forth. Then we have practice or training courses as form of legal education. We have practice or training courses as form of legal education. This usually is to qualify as a lawyer. After obtaining your degree, for example, you will now go for some practical training. For example, where I teach at the Nigerian Law School, the purpose of the education at Nigerian Law School is tailored towards qualifying you as a lawyer. So it is when you have acquired education, when you have gone through the Bar Part 2 course in Nigeria, it is when you are now deemed to have qualified as a lawyer and you will now be given a license to practice law in Nigeria. So that is called practical or specialized training to qualify you as a lawyer. Then we have also applied or specialized law accreditation programs. For example, trainings organized by lawyers and some other experts on alternative dispute resolution, trademark, corporate issues, and so on and so forth. So usually this is noticed in some associations and institutions that set up to deliver this specialized program. Then we have what we call continuing legal education. Continuing legal education is not usually tailored towards acquiring a degree in law. No, they do not lead to any qualification, but they provide practicing lawyers with updates the practical continuing education is to provide you with updates on various areas of law, legal development in your area and other areas. And this usually is delivered through seminars, workshops, conferences, webinars, just like the type we are having today. Now, what are the objectives of legal education? The prime object of legal education is to produce professional lawyers, but this is not all. According to the Committee of Legal Education of the Harvard Law School, the committee lays emphasis on the double purpose of legal education, namely to train men for the legal profession and to provide a center where scholars might contribute an understanding of law and government and participate creatively in their growth and improvement, etc. In Nigeria, for example, the target of legal education could be said to be two-pronged. One is to provide substantive legal education. This is usually done by the universities. This job is undertaken by the various law faculties in Nigerian universities. The second aspect of legal education is to deliver a procedural legal education. The procedural legal education is delivered at Nigerian Law School. It's the only institution that is accredited for the purpose of delivering the procedural legal education in Nigeria. Outside the country, like in the UK, in the US, and some other areas, the university undertakes the role of delivering both the substantive and the procedural legal education. Now, levels of education. In India, for example, legal education is offered at different levels by traditional universities. In India, at different levels by traditional universities and specialized law universities and schools after completion of your undergraduate program. Legal education in India is regulated by the Bar Council, a statutory body established under Section 4 of the Advocates Act of 1961. Any institution imparting legal education in India must be approved by the Bar Council. But in Nigeria, only one institution offers procedural legal education, and that is Nigerian Law School. Now, that takes us to the next outline, origin and development of legal education. Now, we will not waste much time here. All we need to point out here is that early Western legal education emerged in Republican Rome. Sorry, I was interrupted. Early Western legal education emerged in the Republican Rome. Okay, but it developed from there up to where we are now, the 21st century. But the 21st century is characterized by a form of education that responds to the economical, technological, and societal shifts that are happening at an ever-increasing pace. It's an education that sets children up to succeed in a world where more than half of the jobs they will have over their careers don't even exist at all. So the 21st century legal education is a special type of legal education that needs to be all-encompassing, because the training that is being received by lawyers, the aspirants to the bar in the 21st century is no longer tailored towards training them to practice in courts only, or to draft agreements, or to register companies, or to represent companies. There is a wide range of opportunities and careers that a lawyer could pursue. And that is why the 21st century legal education is now being tailored towards training a complete lawyer that can fit into almost all the aspects of careers or opportunities that exist in the legal profession.
Sir, I think there is some technical glitch on his part.
Chanika, so if we have time, we can take some more questions.
No, sir, because there's really crunch of time, so we'll go to the...
The challenges of legal education in the 21st century. I don't know, is my time up?
Yes, sir, you just have 2 more minutes.
Oh, sorry. Okay, so that takes us to the challenges of legal education in the 21st century. Now, sorry, because of the limit of the time, so my main paper, which I'm going to send to you, discusses all this paper, the aspects in detail. So the paper talks about the challenges of legal education in the 21st century. In Nigeria, for example, the major challenge being faced by legal education is funding, followed by facilities. Funding of and then we have
Thank you, Mr. Sylvester, for your valuable thoughts and inputs on the legal education from Nigeria. I think this was really a very fruitful session, and I want to thank all the speakers. They share their thoughts and valuable inputs on the legal education in 21st century. And I think they have covered the wider area of the legal education, that how through basics or value-added education and an exclusive education as well. So what I think that there are 3 steps, like basics, value-added, and the exclusive. Okay, so I hope that audience has benefited from their experience and the inputs on their legal education. Thanks to everyone. Yes, Chanika.
Thank you so much. My dear students, we have come to a very important part of the session, and I'm sure all the students look forward to this part, which is the passing of the resolution. The resolution of this session: we, the participants of the first International Symposium on Law and Peace, hereby make an appeal to all the stakeholders, such as the government, bar councils, and universities, to widen the horizon of the legal studies through integration of legal aspects into all the courses to empower the citizenry with power of the laws. My dear students, you just have 1 minute to cast in your vote, and I'm sure you will not want to lose out on this excellent opportunity for voting either in favor or against of such an important resolution. We, the participants of the first International Symposium on Law and Peace, hereby make an appeal to all the stakeholders such as the government, bar council, and universities to widen the horizon of the legal studies through integration of legal aspects into all the courses to empower the citizenry with the power of the laws. The votes are about to come in. And we have the votes in front of us. 98% of the students have voted in favor of the resolution. Thanks to each one of you for participating in the resolution wholeheartedly. Now we have come to another important part of the session where we administer an oath of loyalty, a promise towards our motherland. Now I shall request Avinish Krishnan for taking the oath on behalf of all the participants. Over to you, Avinish.
Thank you, ma'am. Am I audible?
Yes, you are.
Okay, so I'll be taking the oath for this session. On the platform of MIT WPU's International Symposium on Law and Peace, we, the sons and the daughters of Mother Earth, being the global citizens, are sure to abide by the duties and responsibilities of an ideal citizen, and hereby affirm that we will endeavor to promote peace and harmony through the lens of law in the pursuit of justice.
Thank you so much, Avinish, and I'm sure all the student leaders, all the participants will abide by this promise. Now we have come to the end of this session, and before requesting Dr. Aparna Pathak for the vote of thanks, a gentle reminder to all the participants and delegates all over the world that we will start with a valedictory session at sharp 4:30 p.m. So just a request, don't log out, stay logged in, because we are just about to start with the valedictory session in the next 15 minutes. Now I shall request Dr. Aparna Pathak, Assistant Professor, School of Law, for the concluding remarks and to render a vote of thanks.
Warm greetings. Namaste to one and all present at this August online International Symposium on Law and Peace. I, Dr. Aparna Pathak, on behalf of MIT WPU's School of Law, extend gratitude to one and all who have been instrumental in making this session a grand success. I thank the moderator, Dr. Manoj Singh, who took forth the session smoothly. He talked about the education system of law, whether it is making our students competent enough to compete in the international world, the development and grooming of faculty members in the legal fraternity, so as to make the students to international market competent. Thank you, Dr. Manoj Singh. I also thank Dr. Sangeeta Laha, who mentioned the internet is a boon in legal education, making us connected to all. She explained how there has been a revolutionary aspect in the legal education, which then was not taken as a professional course and now is being supplemented with good internships, revamped syllabus. Its look has also changed due to the pays and perks enjoyed by the students graduating from law schools. Legal education is now being taken seriously, like IITs and IIMs. Moot courts have also helped in honing their skills. The various updates and reforms by the Bar Council and the UGC have helped in organizing and reorganizing the syllabi, and the FDIs in the legal education have helped to upgrade the legal education, though still there is a lot to be done. I thank Dr. Sangeeta Laha. I also thank Dr. Naseem Amir Ali, who spoke about the role of legal education in the 21st century education. He put forth his point in an innovative way, explaining how the law professionals use words which are not easily understandable. He mentions altruism to be the highest degree of professionalism. Linking altruism to legal education is required to be done. There must not be any scope of subjective interpretation, as decoding the legal language is very difficult. We should have plain language understandable to all, as it is possible to draft context in plain language as well without losing the legal content. We are in the 21st century. Why not use plain language instead of using the complex legalese? He put forth many examples of the complex legalese which is not understood by the conman. He advocated that plain language should be used by the legal fraternity. Thank you, Dr. Naseem Amir Ali. I also thank Dr. Priyanka Javale, who put forth that the legal education was channelized with the establishment of national law schools, followed by the private universities. The legal education has reached a status where the students now want to get admission to law schools. She mentioned a survey which was conducted where it was observed that law practitioners said only 23% law graduates have sufficient skills as they are not getting real life field experiences. She mentions our curriculum or degree should be matched with the demands, requirements, challenges of the law professionals. We have to invest into our students' capability building to make them capable with interdisciplinary collaboration. We have to focus on industry and field exposure. She also mentioned that we have to bring out peace lawyers who shall not only be working on corporate fields, but also shall be working on the social front. Thank you, Dr. Priyanka. I thank Mr. Utkarsh Mishra, who focused on critical points of understanding how a student of law is. One has to keep updating by doing a lot of research and studying. Reading, writing, and researching are the paramount parameters of success. I want us to look beyond the act to understand these factors which influence the contractual relationships. We have to have interdisciplinary or multidisciplinary research. We also have to use IT tales so as to develop the vast knowledge base. We have to use the IT tales as the conceptual history even today is relevant, even if we are using the IT tools today. I also thank Mr. Sylvester, who mentioned education is a discipline. Transmission of value and knowledge takes place with education and brings out eminent change. Legal education is the education of individuals who teach values, ethics, and practice law, making good and law abiding, making themselves good and law abiding. I also thank Mr. Avinash Krishnan for the administration of oath. I thank all the participants for having made this particular session a grand success. I thank all the organizers of the MIT WPU, the volunteers, IT team, IT and technical support. And lastly, I extend thank you to each one who has been instrumental in making this session a great success. Thank you.
Thank you, Dr. Aparna Pathak. On behalf of MIT World Peace University School of Law, our heartfelt thanks and gratitude to all the dignitaries, participants, not only for this session, but for all the sessions who took out time from their hectic schedule and could be a part of this conference. A heartfelt thanks to Dr. Manoj Kumar Singh, and of course, to our beloved Dean Ma'am, Dr. Anuradha Parasar, for being the ever-guiding light. And my dear students, you all have been an excellent participant for this conference. And I'm sure like all the 8 sessions have been engrossing enough and you all have learned a lot. So with a promise, I'll sign off, and the promise is the second International Symposium on Law and Peace is going to be even more grand. So on that note, a heartfelt thanks to each one of you once again. Thank you so much. Jai Hind, Jai Bharat. And please stay logged in for the valedictory session, which will start exactly in the next 10 minutes. Thank you once again. Goodbye.
The path towards attainment of peace is always full of hurdles. However, legal deliberations can act as an important scaffolding for the construction of a peaceful culture. The legal fraternity is envisioned to be the harbinger of hope that will lead human beings towards harmony. Law indeed is the means to attain the ultimate goal of peace through amicable dispute settlement, and therefore this International Symposium has been incepted to herald law to promote peace. The first International Symposium on Law and Peace, which is organized by MIT WPU School of Law, aims to become one of the brightest beacons to herald peace and harmony through the lens of the law. The ISLP strives to provide a common platform to legal professionals, youth, policy planners, thinkers, and global society at large, where they can come together for dialogue, open discussions, deliberations, and can use the platform to recommend measures to address conflict resolution through peace-building processes, to promote the culture of peace and harmony for a digitally dynamic and complex society. The main mission of arranging the Symposium on Law and Peace is to promote peace and harmony in global society through lawmaking processes and policy decisions by imbibing the principles of justice, equity, and good conscience, sensitizing budding legal professionals as conflict resolution ambassadors, to initiate dialogue between lawyers, judges, policymakers, jurists, academicians, the youth, society, and industry about legal dimensions and peace perspectives. Law is there for us when we are there with the law. Let's make the best out of this golden opportunity. Welcome to the first International Symposium on Law and Peace.
The role of a witness is very crucial in determining the outcome of a case. The party producing the witness in the court tends to give a favorable testimony on behalf of the party that has produced him, and the testimony of such a witness is negated by the adverse party. A tough situation arises when the favorable witness. Many elements of legal education are influenced by the new dynamics and changes that have emerged in society. As a result, legal education needs to broaden in order for law students, and practitioners to have a beneficial impact on today's world. In India, legal education is undergoing significant changes. Success currently appears to be different than it did in the past. Giving students the skills they need to succeed in this new environment, as well as helping them gain the confidence to use those skills, is at the core of a 21st century education. In recent years, legal education and development have become intertwined notions. Many changes have occurred in the field of legal education as a result of the digital age. The digital age presents an opportunity to revitalize and modernize legal education by making it more individualized, relevant, humanistic, and accessible. The aim of the session is to discuss the scope and evolution of legal education in the 21st century.
Intellectual property rights and competition law are two distinct fields of law that have become of paramount importance, especially in the ever-growing corporate industry, with upcoming entrepreneurs, established businessmen, and innovators competing in cutthroat competition in a bid to win over the consumers in all fields ranging from agriculture to information technology. Competition law governs the companies and establishes standards to be followed so that cutthroat competition doesn't lead to consumers being affected by unfair trade qualities and under-quality goods. IPR protects the businessmen and innovators by safeguarding their unique business creations from being copied or misused by anyone. While in theory, these laws may not seem related to each other, in reality, they have led to one big common incentive for the final consumer: a competitive and innovative developing market. These laws have become the perfect recipe to ensure innovation in compliance with ethical and legal standards, combined with the legal protection to protect the efforts that go behind them. This session will discuss the interface between intellectual property rights and competition law. The path towards attainment of peace is always full of hurdles. However, legal deliberations can act as an important scaffolding for the construction of a peaceful culture. The legal fraternity is envisioned to be the harbinger of hope that will lead human beings towards harmony. Law indeed is the means to attain the ultimate goal of peace through amicable dispute settlement, and therefore this International Symposium has been incepted to herald law to promote peace. The first International Symposium on Law and Peace, which is organized by MIT WPU School of Law, aims to become one of the brightest beacons to herald peace and harmony through the lens of the law. The ISLP strives to provide a common platform to legal professionals, youth, policy planners, thinkers, and global society at large, where they can come together for dialogue, open discussions, deliberations, and can use the platform to recommend measures to address conflict resolution through peace-building processes, to promote the culture of peace and harmony for a digitally dynamic and complex society. The main mission of arranging the Symposium on Law and Peace is to promote peace and harmony in global society through lawmaking processes and policy decisions by imbibing the principles of justice, equity, and good conscience, sensitizing budding legal professionals as conflict resolution ambassadors, to initiate dialogue between lawyers, judges, policymakers, jurists, academicians, the youth, society, and industry about legal dimensions and peace perspectives. Law is there for us when we are there with the law. Let's make the best out of this golden opportunity. Welcome to the first International Symposium on Law and Peace. It has now become a well-accepted fact that artificial intelligence is changing human society as a whole. It is an instrumental part in all tangents of life, whether it is to open a lock on your phone or help track and analyze various types of diseases. AI is being used everywhere. But is it available for everyone? Human rights, as we all know, are universally protected and are the most intrinsic rights that cannot be denied to anyone. Society is seeing a shift where robots and machines are evolving social systems. But is artificial intelligence doing so without any social, racial, and economic bias? Is AI going to be another tool of discrimination? Would AI lead to a new form of oppression? These questions need to be answered. The session would help find these answers and shed light on a topic that needs everyone's attention. Let's discuss in this session the various aspects about human rights laws and artificial intelligence.
Achieved, and it is a very important movement that this first International Symposium on Law and Peace was, I would say, so successful that the networking with global legal professionals, jurists, lawyers, legal advisors, mediators, policymakers, academicians, social observers, administrators, and so all these people this symposium was capable to bring on table. It was important that all these peers get involved and get on one platform to discuss the burning issues in front of our country. Second important objective of ISLP was non-political, non-aligned open deliberations and discussions on prosing issues and the way forward with reference to the rule of law in peace-building processes. This objective has also been achieved. To raise the awareness and sensitivity among the participants about the social legal issues and conflict resolution mechanism in global context and understanding the challenges of law in the context of multicultural multi-ethnic and multi-religious, multilingual global society and digital world. All these 4 important objectives, I'm really happy to share with you that with the participation of all the dignitaries, respected speakers, and all the participants of First International Symposium on Law and Peace were achieved. And now it's time that we take this journey towards the conclusion with the valedictory session of First ISLP, or International Symposium on Law and Peace. Before we begin with this valedictory session, I would like to request my technical team to share with us the national song Vande Mataram, and I would like to request everyone on this digital dais to please rise in their seats for national song Vande Mataram. Over to you, team.
Vande Mataram, Vande Mataram, Sujalam, Sufalam, Malayaj Sheetalam, Shasya Shamalam Mataram, Vande Mataram, Shubhra Jyosna Pulakitayamini, Pulla Kusumita Drumadala Shobhini, Suhasini, Sumadhura Bhashini, Sukhadam Varadam Mataram, Vande Mataram, Vande Mataram.
Thank you very much. My friends, as per the tradition of MIRE's MIT group of institutions, I would now like to request everyone in this August gathering to wholeheartedly participate in a prayer. My friends, generally, whenever we talk about a prayer, the prayer symbolizes a caste, creed, or a religion. But this prayer, which MIT group of institution has been praying for the last 40 years, is a gift of revered Professor Dr. Vishwanath Karad sir to all of us, and which does not talk about any caste, creed, religion, or a particular section of society, but it is a prayer for the welfare of entire humanity. I request everyone to please fold their hands, close their eyes, bring the image of their mother, father, their deity in front of their eyes, and wholeheartedly participate in World Peace Prayer. I request my technical team to kindly relay.
Om Namo Jiyadya Veda Pratipadya Jaya Jaya Swasamvedya Atmarupa Devatuti Ganeshu Sakalartha Mati Prakashu Mhane Nivrittidasu Avadhari Godi Gurur Brahma Gurur Vishnu Gurur Devo Maheshwara Guru Sakshat Parabrahma Tasmai Sri Gurave Namaha. Purnamada Purnamidam Purnat Purnamudachyate Purnasya Purnamadaya Purnamevavasishyate. Om Shanti Shanti Shanti.
Thank you very much. And now I would like to request the co-chairperson of IQAC, Dean, School of Law, Faculty of Liberal Arts, School of Visual Arts and Fine Arts, Professor Dr. Anuradha Parasar Madam, to kindly propose welcome address. Over to you, ma'am.
Thank you, Dr. Bapat, and Sadar Hardik Namaskar to one and all, respected dignitaries on the dais, distinguished honorable members of legal fraternity, Honorable Chief Justice, Honorable Justice of Supreme Court, High Courts, Honorable Sitting Judges, Honorable Former Judges, distinguished senior advocates, members of Bar Association, advocates, lawyers, respected university leadership, trustee members, fellow colleagues, participants, members from media and press, faculty, staff, and my dear students. A very good evening to one and all. Welcome to the valedictory session of First International Symposium on Law and Peace at Dr. Vishwanath Karad, MIT World Peace University, Pune, Bharat. MIT World Peace University is organizing this international symposium in association with the Pune District Bar Association from December 14 to 17, 2021 on the theme, Role of Law to Promote the Culture of Peace. And collectively, we are concluding today one of the most esteemed and prestigious event, the International Symposium on Law and Peace at the revered land of Dr. Vishwanath Karad, MIT World Peace University, Pune. Hearty welcome and greetings to chief guest, guest of honor, distinguished speakers, and delegates to the valedictory session of International Symposium on Law and Peace. Warm welcome to special guest of honor, Justice Gyan Sudha Mishra ji, former Judge, Supreme Court of India. Ardent welcome to special guest of honor, Senior Advocate Praveen H. Parak ji, Padma Shri, Senior Advocate, President, Indian Society of International Law and Confederation of Indian Bar. Hearty welcome to special guest of honor, Dr. Ujjwal Nikam ji, Padma Shri, eminent lawyer and well-known public prosecutor. We extend warm welcome to patron and organizing chair, Dr. Lalit Bhasin ji, Advocate, Supreme Court of India, Managing Partner, Bhasin and Company, President, the Society of Law Firms, President, Indian Law Foundation. We extend earnest welcome to special guest of honor, Dr. Anirudh Rajput ji, member, UN International Law Commission. We also welcome Chief Guest of Honor, Shri Sujit Kumar ji, Honorable Member of Parliament, Rajya Sabha, BJD Odisha, Advisor and Mentor, Lex Mantra, Legal and Business Advisor. We also extend heartfelt welcome to Shri Nanik Rupani ji and all members of Advisory Board of MIT WPU Faculty of Law. We extend warm welcome to Advocate Satish Mulik ji, President, Pune District Bar Association, and all members of Bar Association of various states. Heartfelt thanks and gratitude to all distinguished speakers, delegates, and panelists of International Symposium on Law and Peace from India and abroad. We extend warm welcome to all distinguished panelists and delegates from USA, Turkey, China, Malaysia, Netherlands, South Korea, Brazil, New Zealand, Hong Kong, Germany, Nigeria, Colombia, Seychelles, Guyana, Sri Lanka, Rwanda, United Kingdom, for their contribution in making ISLP successful and truly an international event. We welcome delegates and participants from India, and it's a pleasure to share that more than 30 law colleges from India participated and benefited from ISLP session. We wholeheartedly welcome UNESCO chairholder, Professor Dr. Vishwanath D. Karad sir, founder and chief patron, MIRS MIT Pune, and president, MIT World Peace University, and creator, World Largest Peace Dome. Please join in welcoming the patron and organizing chair of International Symposium on Law and Peace, Shri Rahul V. Karad sir, managing trustee and executive president, MIRS MIT, and executive president, MIT World Peace University, and chief initiator, MIT School of Government, and founder, International Symposium on Law and Peace, Bharatiya Chhatra Sansad, National Teachers Congress, National Women's Parliament, National Conference on Media and Journalism. I also extend warm welcome to academic leadership of MIT World Peace University, Professor R.M. Chitnis, Vice Chancellor MIT WPU, Pro-VCs, Deans, Associate Deans, and Directors. Hearty welcome to all the participants, delegates to the valedictory session of this 4-day online first International Symposium on Law and Peace, which is organized by MIT World Peace University, Pune, Bharat, in association with Pune District Bar Association. We started this International Symposium on December 14, 2021, and today, on this auspicious date, December 17, 2021, on smooth and successful completion of all technical sessions, we are concluding International Symposium with valedictory sessions. And more than 88 distinguished speakers from India and abroad, they deliberated across various technical sessions. And one of the outcomes of the symposium to share with all the delegates here is that 8 resolutions has been passed as the outcome of this symposium, which will be submitted to Government of India in the form of report. And these resolutions are also available on ISLP website for public consumption. And I'm very happy to share that we have received an overwhelming response and very positive and motivating feedback from all international and national delegates and participants. And it is pertinent to share here about the charismatic persona and the visionary of this grandiose and majestic symposium is Executive President, MIT World Peace University, Shri Rahul V. Karad, under whose inspiration and guidance we have witnessed symposium taking shape of an international movement towards heralding law to promote the culture of peace. Thank you, sir, for giving birth to yet another milestone, a great, splendid, and magnificent platform by the name International Symposium on Law and Peace. And given the stature of International Symposium, we feel happy in acknowledging that ISLP will emerge as one of the most esteemed and notable amaranthine annual platform to connect legal luminaries with youth and global society at large. Venue for ISLP is thoughtfully decided as the world's largest peace dome, which is the world's wonder. It's like a peace temple, which was envisioned by UNESCO chairholder, Professor Dr. Vishwanath D. Karad sir, who is founder and chief patron, Myers MIT Pune, and President MIT World Peace University. And Karad sir has strived hard all through his life to establish the culture of peace through various initiatives and through the deliverance of value-based universal education. Once again, on my behalf, and on behalf of Honorable President, Professor Dr. Vishwanath D. Karad sir, Honorable Executive President, Shri Rahul V. Karad sir, Honorable Vice Chancellor, Professor R.M. Chitnis, faculty, staff, and students of MIT World Peace University, and in specific from MIT WPU School of Law, I extend hearty welcome to one and all and show deep sense of gratitude to all distinguished speakers, delegates, and participants for sparing their valuable time and for their unique contribution and participation in making symposium successful and fruitful. Ladies and gentlemen, through this first edition of International Symposium on Law and Peace, delegates and participants are now charged and is made responsible to herald law to promote peace. And this will now be taken forward by thought-provoking address by all distinguished and eminent speakers of valedictory sessions, Honorable Chief Guest of Honor and Special Guest of Honors, who are presently gracing the prestigious virtual dais of ISLP. And before concluding, I extend hearty welcome once again to one and all to the valedictory session of MIT World Peace University's first International Symposium on Law and Peace on the topic heralding peace and harmony through the lens of law, the way ahead. Thank you. Vande Mataram. Jai Hind.
Thank you very much, Dr. Parashar. Thank you very much for that warm welcome to everyone on this dais. And now, as per the tradition, let us ring the bell of peace and ensure that the message and all the deliberations that are happening on the dais of First International Symposium on Law and Peace, ISLP, reach every heart across the globe. I request my technical team to kindly relay ringing the bell of peace. This is the way in which if we would have been in the offline mode, we would have enjoyed this moment where all the dignitaries are joining hands and
a big round of
bringing the
applause,
bell
my
of
friends,
peace,
as we
ensuring
support this
that the message reaches
cause.
every heart.
Thank you very much.
Thank you. And now I would like to request everyone in the panel to please put on their camera so that we can have a very, very beautiful and memorable photograph. I request everyone on this digital dais to please put on their camera and wear a beautiful smile so that we can capture this moment for lifetime. Thank you very much. And now it's time that we understand the details and the nitty-gritties of first ISLP through a small theme film. I request my technical team to kindly relay a small theme film made on First International Symposium on Law and Peace. Over to you, team.
The path towards attainment of peace is always full of hurdles. However, legal deliberations can act as an important scaffolding for the construction of a peaceful culture. The legal fraternity is envisioned to be the harbinger of hope that will lead human beings towards harmony. Law indeed is the means to attain the ultimate goal of peace through amicable dispute settlement, and therefore this international symposium has been incepted to herald law to promote peace. The first International Symposium on Law and Peace, which is organized by MIT WPU School of Law, aims to become one of the brightest beacons to herald peace and harmony through the lens of the law. The ISLP strives to provide a common platform to legal professionals, youth, policy planners, thinkers, and global society at large, where they can come together for dialogue, open discussions, deliberations, and can use the platform to recommend measures to address conflict resolution through peace-building processes, to promote the culture of peace and harmony for a digitally dynamic and complex society. The main mission of arranging the Symposium on Law and Peace is to promote peace and harmony in global society through lawmaking processes and policy decisions by imbibing the principles of justice, equity, and good conscience, sensitizing budding legal professionals as conflict resolution ambassadors, to initiate dialogue between lawyers, judges, policymakers, jurists, academicians, the youth, society, and industry about legal dimensions and peace perspectives. Law is there for us when we are there with the law. Let's make the best out of this golden opportunity. Welcome to the first International Symposium on Law and Peace.
Thank you very much, and I'm sure the message of First International Symposium on Law and Peace would have reached every one of us. And now it's the time when I invite the Honorable Vice Chancellor of MIT World Peace University, Professor Dr. R.M. Chitnis sir, to address all of us on the theme and bottom line of First International Symposium on Law and Peace. Over to you, sir.
Namaskar and good evening to all of you, those who have gathered here for the valedictory session of First International Symposium on Law and Peace. Once again, warm welcome to Chief Guest and all other eminent luminaries who will be addressing us today in this valedictory session. It's a matter of pride and pleasure for us at MIT World Peace University to have organized this first international symposium on a unique subject of law and peace, which was possible because of our founder and the torchbearer of peace, who is also UNESCO Chair for Peace, Democracy and Human Rights. Through holistic education, Dr. Karad sir, and the dynamic visionary leader, our Executive President, Shri Rahul Karad sir, have not only extended full support to this prestigious conference, but also actively participated in the sessions and appreciated the views and discussions of the esteemed speakers. The huge participation, support, and feedback received from all the sessions in the past 4 days stands as a strong testimony of the success of the symposium in terms of its objective and purpose. While the main theme of this international symposium is the role of law to promote culture of peace, and the special theme of this valedictory session is heralding peace and harmony through the lens of law, the way ahead. Looking at the extremely informative, thoughtful discussions and deliberations that took place in the plenary sessions, we can confidently say that with the conviction that both the themes have got very good traction and momentum to take them ahead in the right direction, with the collective efforts of all the stakeholders. Similar to the special theme of this valedictory session, our visionary founder, Dr. Vishwanath Karad sir, started a mission with passion to rightly and rightfully use value-based education for the heralding of harmony and peace among the large number of students at MIT World Peace University in order to transform them into responsible citizens of the country. The foresight and the vision taken up by our dynamic executive president, Shri Rahul Karad sir, who is envisaging to herald peace and harmony through the lens of holistic education now. His extremely nationalistic and strong initiatives such as Bharat Ki Baat, Bharatiya Chhatra Sansad campaign to name our Independence Day as a national day, National Women's Parliament, and many more have been truly inspiring and igniting a sense of national spirit and national pride among the youth of today of Bharat. A strong nation, as Dr. Rahul Karad sir believes, a strong nation builds strong future for its citizens. But a strong nation founded on the solid foundation of law can build a mighty nation for every citizen to be proud of and other nations to follow. And if mighty nations firmly believe in the building and heralding peace, then others bound to follow. A message of this unique international conference of law and peace is very loud and clear. The role of law in building peace and harmony is a huge, and we must exercise our power to make laws in such a framework that it will ensure peace, unity, harmony, and resilience, not only among our countrymen, but for the entire humanity of the world. As the famous quote says, law is not law if it violates the principles of eternal justice. And I feel at this juncture, after this conference, or during this valedictory session of this conference, let's all vow to promote and abide by laws which protect the principle of eternal justice. Once again, welcome to this valedictory and very, very important session. Thank you very much. And next year, when we do this conference, we'll be in the world famous dome in the MIT campus. You are invited right from today itself. Once again, thank you. Jai Hind, Jai Bharat. With this, may I ask Dr. Bapat to take over again.
Thank you. Thank you so much, Honorable Vice Chancellor, sir. And thank you so much for that positivity and confidence that next year we'll be able to see every one of you in the offline mode in the monument of world peace. Indeed, I'm sure the God will give us the power to make your words true. Thank you very much, sir. And one more thing, very rightly, you mentioned in your address that if countries like India and mighty countries like India, if they believe in peace and they follow the practices of peace, all other nations are bound to follow. So very well said, sir. Thank you very much for those beautiful thoughts. My friends, any event, any moment, any new platform needs a very, very strong foundation, very strong support or I would say a backing from stalwarts in that particular area. We all are fortunate enough that for first ISLP, we had as the patron and organizing chair, Dr. Lalit Bhasinji. It was indeed our honor and privilege that we could learn from so many things from Dr. Lalit Bhasinji. He is the advocate of Supreme Court of India and managing partner of Bhasin and Company, president of the Society of Indian Law Firms and president of Indian Law Foundation. This introduction is, I would say, just the, wordish or bookish introduction of Dr. Lalit Bhasinji. The amount of knowledge, the amount of experience Dr. Bhasin has, and because of which ISLP and the entire organizing committee of ISLP is immensely benefited. Sir, we would like to express our deepest gratitude for all the support and guidance that you have provided us. It is indeed my honor and privilege, before I invite him to address the gathering, to request my technical team to kindly relay a small film made on life and work of Dr. Lalit Bhasinji.
Dr. Lalit Bhasin is a distinguished lawyer with over 5 decades of law practice. He started his law practice in 1962 and has developed Bhasin & Co. as one of the leading law firms in India. Bhasin & Co. currently maintains offices in New Delhi and Mumbai and has 28 associates. He is an honorary life member of the International Bar Association, chairman of CIARB India, and a member of the ICC Arbitration India Core Group. He is a former president of the Inter-Pacific Bar Association and a former chairman of the Film Certification Appellate Tribunal of India. He was awarded honorary membership of the IBA in Melbourne in 1994 for outstanding service to the legal profession. He was felicitated with a Plaque of Honour for outstanding contribution to the rule of law in 2002 by the Prime Minister of India and the National Law Day Award in 2007 by the President of India.
We warmly welcome
Dr. Lalit Bhasin.
Thank you very much for that film. And it is, once again, I would like to say, sir, was indeed our honor and privilege to have you on board. We all are eager to hear your views. Over to you, sir.
Thank you, Dr. Bapat, for your very gracious introduction.
Sir, I think you're on mute. Yes, go ahead.
I was on mute, but I was muted by the host.
Achha, oh, I'm sorry.
Anyway, I'm not here as a guest speaker or as someone who can advise or guide anyone. I have been here for the last 4 days, a student, someone who is learning from the experiences, expertise, knowledge, and competence of others, including some veterans in the field of law and justice, and also including some young participants. As I see it, in law, there is always a learning experience which goes on. Someone asked Mr. Fali Nariman that, Fali, now you are into 90s, when will you retire? He says, we lawyers do not retire, we just drop dead. That means we just keep on working, learning, to see whether it is in the... Yeah. So it is a learning experience. So I have been here as a student for the last 4 days. It is a mammoth exercise to hold any event, and more particularly on the virtual platform, you see, for 4 days and with full attendance there. These 4 days constitute, you see, the Symposium on Law and Peace. It is a misnomer to call it Symposium on Law and Peace. I feel, and that is my personal experience, I feel it has been a pilgrimage to peace through the means of law and justice. And for that, the credit must go, you see, to the founder, Professor Dr. Vishwanath Karad, and the dynamic leader, that is Rahul Karad, who has put into motion, you see, this exercise, which involves huge preparation, huge commitment to have not just the national participation, but to have international participation from experts. I have had the privilege of listening to some of the international experts, particularly from Nigeria and other countries, and it was a great learning experience. Well, just now, it is my great pleasure to welcome all the dignitaries who are participating in this valedictory session. This valedictory session indicates that the 4 days event is coming to an end. But my view is this is not the end. It is just the beginning of the new efforts, the new initiative, which MIT Pune, under the able guidance and leadership of Professor Dr. Vishwanath Karad and Mr. Rahul Karad, will keep on having, because this is now institutionalized into annual events. Therefore, next year, you see, you may have still more intellectual inputs and more participation, possibly in a physical mode. I particularly am privileged to thank Dr. Nom as the senior most, one of the senior most participant today, that is Honorable Gyan Sudha Mishra ji, former judge of the Supreme Court of India. She's like my contemporary. I had seen her in Delhi as a lawyer, then as a judge, then in Rajasthan, and eventually coming to the Supreme Court. And also Dr. Anirudh Rajput, Vardi Shri Sujit Kumar, then the faculty members led by Dr. Chitnis, the Vice Chancellor, Ms. Anuradha Parasa, Dr. Purnima Inamdar, and I specially welcome my colleagues in the profession, a very senior colleague, Mr. Praveen Parekh, senior advocate, who is also the president of the Indian Society of International Law and is a very dear friend. And also the well-known lawyer whose name is not just confined to Bombay or Maharashtra, that is Dr. Ujjwal Nikam. I extend a hearty welcome to him and all the faculty members who are present, all the participating teams from different universities and young students. But particularly, I would again like to thank Dr. Vishwanath Karad and Mr. Rahul Karad for putting in place this momentous and historical first International Symposium on Law and Peace, in which in each and every session, we have had discussions of highest caliber from the worthy speakers. And with this, I welcome all of you to this valedictory session. Valedictory does not mean, as I said, the end, it is the beginning for a new initiative. So thank you very much and welcome to all of you. Thank you.
Thank you, sir. Thank you very much. As I was mentioning, it was really a great experience that and I would say our honor that he accepted and guided all of us here at ISLP. Thank you, sir. Thank you very much once again. My friends, now it's time when we go ahead and I invite the special guest of honor of this session, Justice Gyan Sudha Mishra ji, the former judge of Supreme Court of India. But before I invite for the address, I would like to request my technical team, if they can please relay a small film made on life and work of Justice Gyan Sudha Mishra ji. Over to you, team.
Justice Gyan Sudha Mishra is a former judge of the Supreme Court of India. She was elevated as a judge of the Supreme Court of India on 30th April 2010. She has passed several landmark and notable judgments in the Supreme Court of India, including judgments on conflict of interest in the Srinivasan BCCI matter, landmark euthanasia judgment Aruna Shanbag matter, and most recently the Delhi Upar fire tragedy dissenting judgment holding the management liable for colossal loss of human lives and directing them to pay heavy compensation to be used for social causes like building a trauma center. She enrolled as an advocate in the Bihar State Bar Council in 1972, at a time when the legal profession for women in India was rather uncommon and the profession was primarily considered to be a male bastion. Prior to her appointment as a judge, Justice Mishra was also actively associated with the activities of the lawyers and the legal profession, and hence was elected as a treasurer, joint secretary, and member executive committee of the Supreme Court Bar Association several times, which is the premier association of lawyers in the country. We warmly welcome Justice Gyan Sudha Mishra.
Thank you very much for that film. And yes, indeed, it is our honor and privilege, ma'am, that you have accepted to be here today and guide all of us. It is indeed our honor. Please go ahead, ma'am. Over to you.
Thank you. My very dear colleagues, I would say, Mr. Praveen H. Parekh, Mr. Lalit Bhasin, and Ujjwal Nikam, who, although I have not met, but have interacted with him, I would say, through his deliberations and his interviews on the visual media. The organizer of today's function, the chief patron of MIT World Peace University, Dr. Karad, all the learned faculty members of this very prominent institution, and above all, the students, the avid listeners, all the participant guests in today's valedictory session on this very relevant and useful and topic on law and peace. I would first of all say that I'm truly delighted to be associated with my colleagues. I am always saying colleagues and emphasizing this because Praveen Parekh ji, Lalit Bhasin, we were, in the bar, and I would admire them from a distance and look forward to look forward how they have been conducting themselves, which was inspirations to their contemporary juniors, I would say, as we were all in the Supreme Court Bar Association together. And today and later on also, I had very many occasions to interact with them. It's a pleasure to associate myself in today's valedictory session organized by this very prominent university. And I say this because if I see something which is from not very hackneyed lines, but something with the novelty, it impresses me. So the subject of this chosen for this symposium and the debate, and I would say the deliberations, it is law and peace. And I was happy to accept the invitation on this subject. I would have loved to have it in the inaugural, as also, would have loved to hear the speakers on this subject, but for some reason I couldn't associate. But I'm happy that in the valedictory session, I can at the most record my appreciation, first of all, for the subject that they have chosen, law and peace. Peace, of course, isn't, something abstract, which we cannot see, which we cannot notice in the material form, but we can feel it. And law is something which is truly material, where we have to do the interpretations and go into its material aspects in letter and spirit, as also by our discussions and understanding. So the connection between law and peace is a subject to my mind, is something has been introduced with a novelty, as generally whenever this subject of peace is discussed, it is generally associated with something which is spiritual, and it has to do with the spirituality. But we never really thought about it, or not really almost always conscious about it, that law and peace can have a very integral and a very deep-rooted connectivity. As we all know, that law is basically rule of law through the legal precepts, where the citizens, the society at large, has to conduct themselves, operate themselves by following the rules of the governance, following the rules of the systems in every way. And we have to be the disciplined citizens by obeying the legal precepts. But little do we think that it is not something we are supposed, we are like, that the legal norms that we have to follow are not merely to ensure or a pressure on ourselves that we have to do in a particular manner. We have to realize, and especially the legal fraternity of the future generation, the students, that law is for all of us, and the governance and the operation of the system is for bringing peace in the society. And if we obey the law, only then we can have the rule of law through which we have peace and order in society, and correspondingly we realize peace in our lives. I would just say for the young upcoming fraternity into the legal profession, that if you take a simple example of the Indian Penal Code and the Criminal Procedure Code, why are they there? Because if the rule of law is not there, it will be difficult for the society to live in peace, because human beings also are a combination of the human mind and the animal instincts, and it is those animal instincts which pushes a criminal to indulge in criminal activities. And we have to see that those criminal activities are they are booked, they are nabbed into, and they are made to understand that if the wrongdoing is there, if you disturb the rule of law, if you commit a crime, if you commit a murder, if you commit a rape, and even if you tease or do using of unfair means, these are all instances which break the law. So breaking the law, breaking the rule will not be done. This is being shown, this is guided by our legal system. But what we have to understand is that we are not doing favor to anyone. We are doing we are serving the society this way by following the rule of law. So this connectivity on law and peace, I think it's at the national level, at the international level, it's the law which is to be obeyed and to be ensured. But while saying so, this much is for the citizens. But while deliberating on this subject, I felt that, this rule of law and connectivity between peace and the rule of law is also to be understood by the governance at large, that when, to ensure that although we expect the citizens to follow the rule of law, the lawmakers and mostly the law enforcing agencies and the decision-making authorities also have to realize that wherever required, the decision should be taken at a fast pace. I'm a bit guarded in my in expressing myself on this subject, because many a times we see that a very simplistic approach is taken regarding the connection between law and peace. But when implementing law is concerned, the subjective approach to a particular issue should be avoided at all costs. And there, if we want peace, we also need to introspect. Introspection, I have always tried to, this introspection, I guess, is meant not merely for the saintly person, but introspection is to be done at all levels. Introspection has to be done by each organ of the society, legislature, executive, judiciary, and the citizens at large, where we should learn to think objectively, express fearlessly, and for the law enforcing agents and the governance organ will also have to do some introspection, that if we are really committed to the rule of law, we have to see the uppermost consideration has to be whether this is for the benefit of the society at large. But that merely should not be, that concern should not really be, if I use a strong word, it should not be hypocritical, where what we say, kathni and karni, what I say and what I preach, there should be some coordination between the two. So if we say that this particular law is for the good of the society or the community at large, it should also reflect straight away. So while it is important for an ordinary citizen or for all citizens to obey the law, one also will have to see that the enforcement of law also should be with the purity of mind and with the purity of action, and we should not indulge in double speak. because the subject, as I said, is abstract, but the implications are very large, and therefore the understanding also has to be a little abstract. What he said is, thoda kaha, jada samajhiye. Thoda kaha, jada samajhna. So, law and peace, to my mind, it's a very, very serious subject, and it needs to be explored and understood by all, that this word, this expression of peace generally is connoted with the international organization at international level, where war should be avoided. But of course, that also, I was saying something at the governance level. But of course, peace has to be at every level, at all level, whether it is the country, it is the international community, or it is in society. So, but generally, as a student of political science, as a lawyer, we feel that this peace word, generally we associate that, oh, United Nations organization is an organization which is built for peace in the community at the global level. Yes, it is there, but at each unit, at every organ, at every level, we have to understand how important it is to ensure peace by obeying the law, promulgating the law, enacting the law, enacting and implementing it. There should be honesty of purpose and honesty towards implementing it. I say because over the years, in my experience, it fills me with a lot of anguish, many a times, I would say, that we do not really act what we preach. So peace by itself may be a very abstract noun word, but do we realize that how deeply it is connected with the legal norms? So that is why I took this opportunity to compliment this MIT World Peace University, that it has chosen a subject which has a very, very deep and it has a lot of implication in the governance of society. I wish, as I said, I had the opportunity to listen to the speakers so that I could understand all the dimensions. But in this time of pandemic, which is still there, we don't get much opportunity to interact personally and physically. I had the good fortune of going to very many universities in Pune and Maharashtra, but now we are compelled to do this through only the visual medium, where we have the satisfaction, but we don't have the full satisfaction of participating. And I always insist that I want to hear the other speakers. And by nature of our job also, having functioned as a judge, we are very prone to listening. First of all, you have to listen what the other side has to say. And that habit has not yet gone. So I wish I had the good fortune of listening to the other speakers. And because in that event, I would have been able to say something more by listening to the speakers, which have provoked me to give me my thoughts to it. So if you have the link, you can share it with me. I can listen those, at leisure. So when I saw the guest list of the speakers, I was delighted to see that Praveen Parikh ji is there, and Lalin Bhasin ji is there, Dr. Karad is there, and of course, the members of the faculty. I look forward, maybe we'll meet sometime at a happy time and on a happy occasion. I wish all the best. I wish a great future to this institution, and would say that if you have carved out, you have envisioned a university which is not one of those, typical ones where we just teach the acts and the provisions and the different subjects. But I'm sure this university can, from the name itself, I can figure out that it is the eagerness to do something different. So if you can put this, this idea is sunk into the students who are studying here, that we have to do things differently, honestly, and with a well-meaning purpose that you really mean what you preach. These days, whenever I have an occasion, I always, say that, this we must learn to be less diplomatic and say things with dignity. So I always focus and say that people must learn to express themselves objectively in whatever way. Because why I say this, because in these days, and during my interactions with people, I have felt that, people, there is a tendency to express ourselves on a particular ideology followed by the parties. Please excuse me for being a little forthright in this, that and I say that and sometimes I tease quite a lot of them. Why do you speak? You must, whatever is in the interest of the society, because we are not into politics. We don't have that inner urge that tomorrow I am going to get or I am a party worker. So why should you be supporting or opposing a cause which on the party list? Learn to think objectively. And I take this opportunity most of the time to say this, that it's high time that we bring the upcoming fraternity with an objective mind, and justice-oriented approach, because justice is not really, you young students, please bear in mind, justice is not a domain of the lawyers and the judges. Justice, there's a judge in each one of us. We must support or oppose a cause. We must learn on merit-based thinking, and we have to demonstrate that we ultimately need the society to grow in every way. I think the subject itself is that there's some some abstract thoughts are coming into it, but once again I thank the organizer and especially Smita, who was coordinating with me and motivating me to join the program. And I'm truly happy, especially, the novelty is reflected. I can't restrain myself from mentioning, these very many years, the introduction of the speakers, but this is a very novel idea on the part of the organizer to introduce, because it becomes to introduce the speaker through their visuals, which gives a slightly interesting dimension to the person's personality. I was quite happy that this university is truly doing something differently, not merely in their, I do not know, in their study curriculum, but they're also doing it in the functions. It is a very novel way of introducing a speaker. So that also, I took an opportunity to record it, because it's a very novel idea that I saw in this function. And as I said, I would have been delighted to hear the speakers, the debaters who had participated in this. And I look forward to visit the university sometime when when there's a happy time and there's no constraint on us. I wish all the best. I wish the institution a great future. I wish the students a very bright future. And my compliments to all of you for organizing this function. Thank you. Thanks a lot for including me. Thanks.
Thank you very much. Thank you very much, Justice Gyansudha Mishra, ma'am. Thank you very much for your kind words. Indeed, many important points you discussed in your address, and as you rightly said, that peace has to be there at every level, may it be in the state, country, or at global level. Unless we have it at all levels, it is not possible to see the dream of peace in the world. You also said very, very important message. You mentioned that we as individuals, we should be less diplomatic, and we should be open, and we should be able to put our views very clearly across. I'm sure it's going to be difficult for many of us, but indeed, when the message comes from the person like you, it is worth following. Thank you very much, ma'am, once again, indeed, from the team of First International Symposium on Law and Peace, that you accepted our invitation and you are here today. Thank you very much, ma'am. My friends, it is now time when I invite the next special guest of honor of this evening, Padma Shri Senior Advocate Praveen Parekh ji, the President of Indian Society of International Law and Confederation of Indian Bar. He is the special guest of honor of today's session, and it is indeed our pleasure and honor, sir, that you have accepted our invitation today. Thank you very much for that. I request my technical team if they can please relay a small film made on life and work of Padma Shri Advocate Praveen Parekh ji.
Advocate Praveen Parekh is a president of organizations like the Indian Society of International Law, a confederation of Indian Bar and Supreme Court Bar Cooperative House Building Society. He is also a Secretary General of the International Institute of Human Rights Society. He has been practicing in the Supreme Court of India since 1969. Advocate Praveen Parekh has done his BA Honours with Economics and Statistics, Elphinstone College, Bombay, and LLB in First Class from Government Law College, Bombay. He headed P.H. Parekh & Co., which was one of the premier law firms in the Supreme Court of India from 1975 to 2006. He was associated with a large number of international organizations worldwide, including International Law Association and the International Bar Association, the America Bar Association, as well as several Indian organizations. He has represented Presidents of India and Vice Presidents of India in the election petitions, Government of United States of America, number of present and past Union Cabinet Ministers, Chief Ministers, State Ministers, Court Foundation, Election Commission of India, Bombay High Court, Patna High Court, Consumer Educational Research Center, Press Council of India, among others. He has been conferred with the Padma Shri by the Honorable President of India. We warmly welcome Advocate Praveen Parekh.
Indeed, sir, it is our honor and privilege to have you here today, sir. We all are eager to listen to your views. Over to you, sir.
Yeah, Justice Gyansudha Mishra ji, Mr. Vice Chancellor Chitnis, Dr. Ujjwal Nikam, Mr. Manat Kumar Mishra, Dr. Lalit Vasin, Dr. Anirudh Rajput, Sri Sujit Kumar, Sri P. Rajiv, ladies and gentlemen. I thank the organizers and the participants for a very important discussion which is taking place today. MIT Group runs several social initiatives, amongst which the Symposium on Law and Peace was established with an objective to provide a common platform to legal professionals, planners, youths, and society for an open dialogue on peace and harmony through the lens of law. Today, we have come to discuss the role of law in the peace-building process. Peaceful change and developments are significant for the free world. The rule of law essentially serves as a guiding principle of peace-building activities. It not only serves to settle specific disputes, but also provides a sense of security in the daily life of men. Compliance with the law leads to situations where people respect the fundamental rights of others, offering enhanced stability to society as a whole. Law provides both justice and order with a special emphasis on individual freedom and social security. Thus, respect for a law as a basis for stability and peace must be developed by all of us. Establishment of rule of law is vital for securing immediate security and necessary stability for peace building to take roots. Therefore, the lawmakers have always aimed for peace. Law has been regulating human rights conduct for many centuries now. It allows certain rights, imposes restrictions, and provides justice to the aggrieved parties. One of the fundamental objectives of law is to establish and maintain peace in the society, and in its absence, there always exists a threat to peace and security. Some of the greatest challenges to the peace arise from the crimes committed against national territory, penetrating borders, and affecting the international community as a whole. In 1945, the United Nations was established with an aim to secure peace and security globally. The Charter of the United Nations has mentioned that the purpose is to bring about settlement of disputes in conformity with the principles of justice, which might lead to breach of peace. It provides a standard basis for friendly relationships among the states. With a wider body of international law, it has provided a structure for maintaining international relations. In particular, importance has been given to peace and security as principles of territorial integrity. The Charter has also provided means for settlement of disputes among the parties through various means in recognition of the importance of the prevention of conflict and peaceful settlement of disputes. Respect for laws generates an enabling environment for achieving the objectives of peace. An effective rule of law helps prevent crime and conflict by providing appropriate means for the resolution of grievances. The states, in recognition of this, have acknowledged the right to protect, establish peace and security. Our Constitution has also endeavored to promote international peace and security. I believe that one of the essential for the maintaining societal peace is that the people have easy access to justice. So in case their rights have been infringed, they have a legitimate system to vindicate their rights and secure justice. This leads to trust and social stability as judiciary functions of the peaceful resolution of this conflict. It will require patience and perseverance to establish peace through law. We will have to set examples by accepting standards of conduct more advanced than those prevalent in society. The members of the legal fraternity will have a major role in this process, and therefore we should dedicate ourselves to this mission of establishing peace and harmony with law. Considering the role of law plays in peace building and promotion, I very much appreciate the efforts taken by MIT to organize this symposium on law and peace, highlighting the role of law in promotion of peace and for discussing the roadmap to address the challenges with respect to peace building. Thank you very much.
Thank you very much, Advocate Praveen Parekji. It was really It was indeed our honor and privilege, sir, that you took time out from your busy schedule and came all the way here on this online platform to discuss and deliberate and share your views on this important platform where all the academicians, students, and I would say peers associated with law are present. Thank you very much once again on behalf of entire organizing committee of First International Symposium on Law and Peace. Thank you, sir. Thank you very much. My friends, it's now time when I invite the next person. Probably you'll find probably not find anyone in India who does not know this name. A person who has fought many, many eminent cases and proved the ruling of law and importance of justice to every citizen of this country. Padma Shri Dr. Ujjwal Nikamji, eminent lawyer and well-known public prosecutor, is here with us, sir. It is indeed our honor and privilege to have you here today. Thank you very much for taking time out and joining us today. I'm sure everyone present here is keen to listen to your words and your views on this important platform of First International Symposium on Law and Peace. Before, sir, I request you to address the gathering, I would like to request my technical team if they can please relay a small film made on life and work of the special guest of honor of this session, Padma Shri Dr. Ujjwal Nikamji.
Advocate Ujjwal Nikam is an Indian special public prosecutor who has worked on prominent murder and terrorism cases. He helped prosecute suspects in the 1993 Bombay bombings, the Gulshan Kumar murder case, the Pramod Mahajan murder case, and the 2008 Mumbai attacks. He was also the special public prosecutor in the 2013 Mumbai gang rape case, 2016 Kopardi rape and murder case. Advocate Ujjwal Nikam argued on behalf of the state during the 26/11 Mumbai attack trial. Advocate Nikam was born in Jalgaon, Maharashtra, to Marathi parents. After receiving his Bachelor of Science degree, he earned a law degree from KCE Society's SS Maniar Law College in Jalgaon. Advocate Nikam began his career as a district prosecutor in Jalgaon and worked his way up to state and national trials. In a 30-year career, he has secured 628 life imprisonments and 37 death penalties. Some of his high-profile cases also include Khairanjali massacre, Kopardi rape and murder case, and the 2003 Gateway of India bombing. Advocate Nikam was awarded the Padma Shri by the Government of India in 2016. We warmly welcome Advocate Ujjwal Nikam.
Thank you, sir. Thank you very much once again. Over to you, sir.
Thank you very much. The founder of MIT University, Honorable Dr. Vishwanath Ji, Pro Vice Chancellor of MIT World Peace University, my friend Dr. Chitnis, Honorable Justice Mishra, Managing Trustee Rahul Ji, Senior Advocate Praveen Parekh Ji, and the other distinguished audience and my friends. Indeed, it's my privilege today to be here online on MIT First International Symposium on Law and Peace. I have no hesitation to say that this is for the first time in India, such has been organized by MIT World and Peace University, which is in fact the need of the time. The moot question is whether peace can be maintained through process of law or not. Since I'm practicing on the criminal side and conducted many high-profile cases against the terrorists and the organized criminal, I must share some of my experience and must elucidate as to how peace can be obtained through process of law. Dear friends, there is no internationally agreed definition of terrorism. By and large, one can say that those acts which are intended to create terror in the mind of the people can be said as a terrorist act. But there is no unanimity on this aspect. Now, instead of the direct war, some countries are interested through proxy war. And we are experiencing a long time about the proxy war. Now, the moot question is how peace can be obtained through process of law. I would like to give the one practical illustration. Now, the Mumbai city was attacked on the night of 26 November 2008. 10 terrorists came from the Pakistan. They attacked Mumbai for certain goal. And accordingly, 9 terrorists were killed in police encounter. One terrorist was apprehended, and the trial was proceeded. While conducting the trial against Ajmal Amir Kasab, the Pakistani lone surviving terrorist, a legitimate query arose in my mind. The criminal conspiracy was hatched outside India, and in pursuance of the criminal conspiracy, these 10 terrorists were sent to Mumbai for attacking the various places. Why did they attack Mumbai? What was their object? And who were the conspirators behind the curtain? Conspirators are always the director of the movie. Friends, you know, the actors, they act accordingly the direction of the director, and the director remains behind the curtain of the scene. So these 10 terrorists were the actors, and the main conspirators were outside India, and they were interacting with these terrorists on the mobile phone. Our intelligence agencies had intercepted the said telephone conversation. And then we got the answer as to why they attacked Mumbai. It was, in fact, to wage a war against the government of India. Dear friends, if you see the definition of the waging war against the government of India under section 121A of the Indian Penal Code, it is a long, obsolete definition. The British has enacted that particular provision because during that time, British were ruling India. And according to the section 121A, if conspiracy to wage war means if anybody wage war against the British government, then they have to be called as a British waging war. Dear friends, as you all are aware, the targets of the 26th November were CST railway station, Hotel Taj, Hotel Oberoi, Nariman House. They were not the government organization or government installation. So one can say, and how can we say that it was a waging war against the government of India? But on the basis of the intercepted conversation of the mobile phone, which we have interacted between that conversation was between the attackers and the handlers who were operating the control room from Karachi, we convinced the trial court that it's a wage war against the government of India. Ultimately, the Supreme Court of India has accepted our contention. So we have to make the radical change. But the question that was cropped up about the main conspirator. I know the simple funda of a logic, that is what we call as a syllogism in logic. Law appreciate to draw irresistible inference from certain proved facts. Syllogism in logic says, all men are mortal, all kings are men. These are two universally true equations. And the third irresistible inference that we can draw from the first two earlier equation, all men are mortal, all kings are men, and therefore all kings are mortal. This is the third irresistible inference. Law accepts such type of irresistible inference. What I would like to emphasize at this juncture, that we have drawn the irresistible inference in the trial, that these 10 attackers were only the soldiers. They were sent from Pakistan with the connivance of the Pakistan army official, and therefore we have agitated this down on international platform. To look what they are doing. Accordingly, the Pakistan was compelled to apprehend some of the conspirators, though they did not apprehend the main conspirator, that is Hafiz Saeed and Zakir Rahman Lukhi. After execution of Ajmal Kasab, the government of India sent 4 persons nomination, the official delegation to Pakistan. I was one of the members. We had been to the Pakistan at Islamabad. We had interacted with the Pakistan army officials and the home ministry officials. We pointed out that why you did not prosecute the main culprits, the main conspirator. They say that give the evidence. You see, still this time, they are not prosecuting the main culprits. The reason is this. They say that we want an evidence. It's a very fishy and funny thing that a criminal conspiracy was hatched on your soil, and still you are asking the evidence from us. So, dear friend, later on we examined the David Headley, we gave the evidence, that is a different question. So in short, what I would like to say, that we had to make such law omnipotent on international basis, that if there is a case of a terrorism, and if terrorist comes from the other soil, other country's soil, then certainly that the global, that is the, I can say that the world, exactly, I can say that we have to make certain changes on the international platform basis, so that the United Nations Security Council also should intervene at this juncture. Like an extradition also. I have faced the problem of the extradition. It's a very interesting thing. Even though we have an extradition treaty with the foreign country, but the foreign court assess our evidence on the basis of their law. In Gulshan Kumar matter case, when we produce our evidence before the post-street magistrate, saying that this is an oral dying declaration given by the deceased person. According to the Indian law, the oral dying declaration is admissible in law. According to the English law, it is not admissible. But the foreign court assess our evidence on the basis of their law. This is something technical hitch. I have suggested the government that we had to make such radical changes in the international law so that peace can be maintained through the process of law. There are a number of examples I can give.
There seems to be some technical glitch, but I'm sure we would be able to get him back online. Sir, can you hear us? So I think, no, you're on mute, sir.
Hello?
Yes, now it's good. Yes,
hello?
Please go ahead, sir. Yes.
I'm sorry for disturbance, because I'm sorry, I had to catch the flight, I had to go. And I think, may I wind up my discussion at this juncture, because this is a long period, I had to catch the flight, I had to go outside.
Sure, sure. No, indeed, I think we lost him again. But nevertheless, I'm sure we all understood the message, and it is indeed our honor that he was here. He's back, he's back.
Hello?
Yes, we can hear you, sir.
Yeah. Sorry, this is some technical problems popped up. But in short, what I would like to say, but peace can be obtained, of course, through the process of law, and therefore dialogue and the necessary radical changes on the international basis are necessary. Therefore, for that purpose, consensus is also needed. And consensus can be needed only by holding such type of international
I think technology is really suffering. But yes, indeed, we had this message very, very clear that I'm not sure if.
Hello.
Yeah, he's back. He's back.
I'm sorry because
That's
there is some
right,
disturbance.
No. So this pandemic has taught us all these technical glitches. No worries.
I'm extremely sorry.
No.
And I will sum up in short that I must congratulate the MIT World Peace University. Am I clear now? Am I audible?
Yes, you are, sir. Yes,
hello?
Very, very loud and clear, sir. You're audible, sir.
Marks.
Yeah, no, I think he's losing his connection very frequently.
Hello.
You're audible, sir.
Remarks,
Hello?
Mr.
Am I audible?
Yes, yes, sir. Yes, sir.
Yes. Hello?
Yes, you're audible, sir.
Am I audible?
Yes, sir.
Yeah,
Yes,
yeah,
sir.
yeah. Thank you very much. Yes. So in short, what I would like to say that we have to make consensus, and this consensus can be done only to the through our university like the MIT World Peace University. And I have a strong faith that Honorable Vishwanath ji, he believes in the God. And of course, such peace can be obtained through necessary dialogues. And one on the other ground, the countries who are indulging in such type of unlawful, illegal activities would come to know that peace is absolutely necessary in the welfare of the
Society.
Yes. Thank you very much, Ujwalji. Thank you very much for taking time out in your busy schedule. You had to catch a flight, but still you took time out for us and participate in first ISLP. Thank you very much indeed. Well, we have lost the connection with him, but I'm sure our feelings and our message would definitely reach him. He has quite well underlined that the unfortunately definition of terrorism is not there in this world, but the process of law can bring peace. Thank you very much for that thought. And whenever we are talking about peace, I would say the work that is done by our Prernalaya revered Professor Dr. Vishwanath Karad sir is the beacon of light which we can say to entire humanity, which keeps giving the message to the entire world that the need of peace in the world. I still remember that always revered Professor Dr. Vishwanath Karad sir say a few words, and those words are: if we don't understand and learn to live peacefully together, we'll have to perish miserably together. It is really, those words keep reminding us the importance of peace and the urgent need to discuss peace on such platforms. Before I invite revered Professor Dr. Vishwanath Karad sir to address the gathering, I would like to request my technical team to share a small video which we'll share with everyone in the audience. And Justice Gyan Sudha Mishra ji is also here with us. Lalit Bhasin ji is here, and all stalwarts are here with us. They'll understand the mammoth work revered Professor Dr. Vishwanath Karad sir has done in last 40 years. A monument that he has created, which is dedicated to entire humanity for bringing and underlining the importance of world peace. I request my technical team to kindly relay the film. Technical team, we are unable to, yeah.
This country has always propagated one thought, Vasudhaiva Kutumbakam, my dear friends. I must say that in the entire history after the independence since 1947, this is one of the unique steps towards the contribution of universal humanity. I appeal to the Vice President and Honorable Chief Minister to recognize this World Peace Dome as a structure of national and global importance and support to promote it in such a way that it evolves as one of the prominent tourism destinations of the world.
We should remember and respect like Professor Vishwanath Karad and millions of people like that, and remember the great service they have done. They should be remembered forever. That is also equally important for all of us. This is the message of this dome. This is the idea of the dome. This is the tallest, not only in size, but also in ideas.
But if he takes away the rest of the days of my life and gives me one day where I can come back and look at this magnificent dome, magnificent message to the rest of the world, to me, this is not just the biggest dome in the world. To me, this is the biggest idea, the biggest message to the world.
Science without religion is lame, and we all know this: religion without science is blind.
सीता का मान नहीं करोगे तब तक श्री राम का मान संपूर्ण नहीं होगा, आप याद रखिए। केवल जय श्री राम से बात नहीं बनेगी, जय सीताराम कहिए, कहना होता।
हमको लगता है कि आज गांधी जी हों चाहे जो कोई हो, सबका इशारा विश्व शांति का है।
विवेकानंद ने कहा है कि 21वीं शताब्दी में मेरी भारत माता ज्ञान का दालन बोल के उभर आएगी। इट विल बिकम अ विश्व गुरु इन द 21st सेंचुरी। उसका छोटा सा उदाहरण, छोटा सा सिंबल यहाँ बन गया है, ऐसा मेरा मानना है।
Thank you very much for that film. And I would now like to request the founder and chief patron of MITES MIT Pune and president of MIT World Peace University and creator of World Peace Dome, UNESCO shareholder, revered Professor Dr. Vishwanath Karat sir, to address the gathering as the chief patron of First International Symposium on Law and Peace. Over to you, sir.
Honorable Dr. Lalit Bashir Sahab, Honorable Senior Advocate Praveen Parekh Sahab, Justice Gyan Sudha Mishra ji, and especially when my friend has already left possibly for his own journey to some other place, Dr. Bujwal Nikamji, and all other learned speakers and the learned scholars who have been addressing this very unique symposium, the International Symposium on Law and Peace. Friends, it has been a very highly satisfying experience for me and my friends, all my students, to learn and understand the wonderful words of wisdom which have been spoken by these great men, and especially concerning promoting the culture of peace in the world. Peace or culture of peace to promote the holistic peace-loving society. Friends, you can certainly know that I have been engaged in this mission for quite some time, but the people have been asking me a question. Professor Karat, you have been trying to speak on world peace, promoting culture of peace. Union of science and religion of spirituality alone will help to bring peace and harmony to mankind. So many seminars, conferences at the world level, at the international level, we have been trying to discuss and deliberate. And finally, we have come to the conclusion and the evolution of the very small but a wonderful example, possibly in the known human history, the first unique monumental creation of the philosophers and Jnaneshwara World Peace Dome and the World Peace Library. But after all possible contributions which I could make in the form of a Ram Rahim Manavta Setu or the Tathagat Gautam Buddha Vihar, trying to promote this very spiritually oriented library. It is also called as the spiritually oriented scientific laboratory to convey the very unique message to promote this culture of peace. And today when we are discussing on the topic of law, the rule of law, and that too in the presence of the very great learned scholars in the field of law and judiciary, who have been the great eminent thinkers and philosophers, who have spent their entire life possibly to understand exactly what should be the rule of law and what law can bring peace to the whole of the world, the global society. Friends, I can only just make a comment that one of my friends, Mr. Vijay Rao, has been telling me what is the rule of law of the nation. And he says the rule of law of any nation must run close to the rule of life of the people. And the rule of life of the people must run close to the rule of Mother Nature. Vishwatmak, universal law, which is unchangeable, which cannot change. Because that rule of law, rule of Vishwatmak, universal consciousness, is a very unique law which is uniform throughout the Mother Nature. It's a very long story behind, but the basic words which were uttered just now by Dr. Vijay Bhatkar and Mashalkar, the great scientists, about the very unique functioning of these various laws of science and spirituality too. And on this background, when we are discussing this issue of law and peace, possibly, friends, I had the fortune of attending the Hague Appeal for Peace conference about 20 years back. And the discussion was that some people sitting in the audience and having a roundtable conference, possibly from very high level delegates, I was asked the question myself by some people. They said, Professor Karad, you have been talking about peace, world peace and so on. आपको मन शांति है क्या? ऐसा पूछा मुझे. उन्होंने कहा कि आपके दिल को, आपके मन को मन शांति है क्या? आपके घर में शांति है क्या? Was the question asked. And then what is the system that can help you to make your family or your own mind, your own heart? आपको आत्मा शांति है क्या? ऐसा पूछा था. And I had to really tell them very frankly and openly, friends, that I said, difficult to answer. I cannot claim that I have really a peace of mind. And what is mind was the question being discussed. What is that brain, the intellect, and the mind which makes me act in whatever way I have been trying to act? So many things were discussed, and finally there was a comment also that, friends, remember, and we are all aware that the entire world today is also passing through a tense and chaotic stage, even worse than what was experienced during the two world wars. The present one is also a war between good and evil, sacrifice and greed, virtues and vices, tolerance and stubbornness, religious coexistence and fundamentalism, traditional time-tested values and quick gains and so on, the ego, anger, jealousy and hatred, and so on. The various issues involved are not only local and restricted to one's own country, but are global as well. The world is witnessing mind-boggling scientific and industrial developments like artificial intelligence, internet, IT, nanotechnology, journey to the outer space, and whatnot on the one hand, while on the other hand, there is a total chaos, confusion, terrorism, bloodshed and massacre taking place in the name of some caste, creed, race, religion, and trivial issues like boundaries of nations. Friends, you are all very scholarly people, learned people. I'm not trying to advise or give some very unique message which I do not want to claim. But one thing is certain, that today the world is in a different mode because of this coronavirus and pandemic. The world has been given a clarion call, like the bell of Hiroshima, ringing once again. Remember that event of Hiroshima and Nagasaki. That bell has started possibly ringing very loudly, giving this clarion call to the whole world to be careful while devising these chemical and biological weapons, atomic weapons, neutron weapons, the neutron bombs and everything. I'm deviating the subject to a certain extent, but when we are discussing about promoting the culture of peace in the world, what is our duty and what is the duty of all the Security Council members, and what laws can prevent these people at the global level, who can prevent and make them think tens of times how to control the mad race of the power game. Otherwise, the situation is getting worsened more and more. And that time, this law or the rule of law is going to play a very crucial role. And we may have to pass some unique rules of law or the regulations at the international level possibly, which will try to help to bring some harmony and peace to mankind. नहीं तो ये अच्छा नहीं लगता है. ये जो रेस है ना, बड़ी दुख की बात है. अपने at the national level, state level, or the normal laws which we normally pass, or the rules and regulations, either the criminal or civil or any other laws which we normally deal with. Yesterday, I really appreciate one gentleman, I don't remember the name, but he said when there are about so many crores of cases pending in the courts, the persons like Lalit Bhasin Sahab and many others who are in the audience and who are advising us, I think their talent and their skill has to be taken care, and they should be given some responsibility. They will do it for the nation. There are so many wonderful suggestions which I heard from yesterday, and I have a feeling that this symposium will certainly try to show a small pathway of using the rules, regulations, and the laws of the nation, laws for the well-being of the mankind, laws to promote the culture of peace in the world. So many words can be spoken, but friends, remember, I really appreciate Lalit Bhasin Sahab said that he has been so deeply involved and he has been so deeply interested in this, understanding the views of so many people, finding time for this. Even all these people, Mr. Parekh Sahab, Nikam Sahab, and many others, I can see here the number of people here. But I think it has been a very essential feature of the education itself, promoting the culture of peace through value-based universal education system. So in the field of law and judiciary too, we will have to think tens of times again that what should be and what should not be the law and the regulations which we normally adopt, and how to deal with this whole mission of promoting the culture of peace through the important mission of championing the field of law and judiciary through value-based education too. Thank you, friends. I'm grateful to you. I have no words to express my feelings for all the great men who have shown and encouraged this institution of World Peace University, which has been trying its level best to at least contribute some little share in organizing and trying to give a very unique message of what this Mother India stands for. वैश्विक भारतीय संस्कृति का एक अलग सा दर्शन है, उसके साथ वेद उपनिषद से लेके all the new scientific great people of the world, they have to sit together with people like you and possibly try to evolve some new mission for promoting this education system of law and judiciary to promote this culture of peace in the world. Thank you, sir. Pranam. President Sahab, pranam. Namaste.
So thank you very much for your words. The words have always been guiding for all of us, everyone at MIT World Peace University family. Thank you very much, sir, once again for your time. My friends, it is indeed my honor and privilege to share with you that we have special guest of honor, Dr. Aniruddha Rajputji, who has joined us, the member of United Nations International Law Commission and consultant at ISLP. Thank you, sir. Thank you very much for taking time out and joining us. But now it's time when I invite the chief guest of this valedictory session, Honorable Member of Parliament of Rajya Sabha of BJD Odisha and advisor and mentor of Lex Mantra Legal and Business Advisory, the chief guest of this session, Shri Sujit Kumarji. Thank you, sir. Thank you very much for taking time out and joining us and accepting the invitation from our side to be the chief guest of this session. Before I invite him to address the gathering, I would like to request my technical team if they can please play a small film made on life and work of Shri Sujit Kumarji.
Shri Sujit Kumar is a member of parliament representing Odisha in the Rajya Sabha. He earlier served as senior policy planning positions with Government of Odisha, as the advisor in the rank of Chief Secretary to the Special Development Council of the Government of Odisha and Special Secretary of the Odisha State Planning Board. He is a trained engineer, lawyer and a policy maker. Shri Sujit Kumar completed Bachelor of Engineering from Veer Surendra Sai University of Technology and Bachelor of Laws from Sambalpur University. He started his career as a software engineer with Infosys Technologies Limited. Later, he shifted to the development sector and worked with the United Nations Development Programme, managing its ICT for Development project in Odisha, working to bring digital technology to the remote regions of the state. Shri Sujit Kumar has unique multidisciplinary experiences in the corporate, government and development sectors. He has travelled widely and spoken in numerous conferences and forums in India and abroad. He received the prestigious Youth Inspiration Award of 2017 for his innovative work as a policy maker, legal entrepreneur, and for his cutting-edge work at the interface of law, technology, development and public policy. We warmly welcome Shri Sujit Kumar.
Thank you very much, sir. Once again, thank you very much for kindly accepting our invitation. Over to you, sir.
Thank you very much. Good evening, everyone. It's a great honor and privilege to be part of this valedictory ceremony of the first International Symposium on Law and Peace. And the theme can't be more apt, heralding peace and harmony through the lens of law and what's the way forward. I feel so humbled to be in this august presence of such luminaries from the legal field, from the academic field, and from different walks of life. Really, it's humbling for me to be part of this ceremony today. And I don't think I deserve to be the chief guest. Honestly, I have come to learn rather than to share my knowledge or wisdom. But nevertheless, let me compliment the great vision of great education of Dr. Herald, for setting up this MIT group of institutions, which has been doing such pioneering work, such commendable work in the field of education in the country. And his work is being very ably carried forward by, say, Rahul Karad, the managing trustee and executive president of this group of institutions. And I must particularly mention about the Bharatiya Chhatra Sansad, which I had the opportunity of interacting with a couple of students when they visited Delhi in March of this year. What a great bunch of students! What a great talent pool that you have cultivated, Mr. Karad. I must really commend you for that. Now, the topic which I have been assigned to speak today on is the administrative and political challenge in front of the Indian judiciary and some of the possible reforms that can be taken up by the judiciary. Again, this is so apt because only this week the Parliament debated the High Court and Supreme Court Judges Amendment Bill 2021, and close to 20 MPs spoke in the Rajya Sabha about this bill. There was nothing much in the bill per se. So the members of parliament had a field day speaking on many aspects touching upon the judiciary and the relationship between the executive and the judiciary, or the legislature and the judiciary. So that has given me an opportunity to share some of the thoughts which I have culled from the parliamentary debate and parliamentary discussion. And cutting across party line, almost all the MPs expressed their concern about the dependency of cases, which is probably the biggest issue plaguing the Indian judiciary today. I mean, all of us know about the staggering statistics. I need not repeat that. And the worrisome aspect is that a bulk of this pendency is multi-year. You know, I'm told that over 77% of the 4.5 odd crore cases that are pending in different courts of India are more than a year old, and this number is even higher for the constitutional courts. For the High Court, it's 85%. Indeed, very staggering number and very, very worrisome. And this pendency is not only limited to the courts, it also extends to the tribunals. Right? A report by Alvarez and Marcel, which is a management consultancy, tells that the average age for cases to be disposed of in the tribunal, in the NCLT rather, is about 6 years old. And the legislation requires that NCLTs to dispose of cases within 270 days, right? So that's the gap that we are talking about. So I second my fellow colleagues in the parliament when they expressed their concern about this huge pendency of cases. Now, whether the judiciary is responsible for it, or the parliament is responsible for it, or the executive is responsible for it now, I mean, this is debatable, but nevertheless, we have this massive concern and massive challenge that we have to worry about. World Bank doing business report, and in the last improved. But there is one area, so there are about 12 parameters or indicators in which various countries are ranked, and India had a very lowly rank of 130 odd until 2016-17. But in the last 2-3 years, the rank significantly improved, and now we are at a respectable 60 odd number. But one area where we are still at a staggeringly low number is in terms of enforcement of contract, where we are ranked 163 out of 190 countries, right? So this again goes to the basic issue of pendency of cases. And so again, the issue why investors are oftentimes reluctant to enforce their contracts or go for arbitration in India. So you have peculiar situation where two Indian entities decide to arbitrate in a third venue, whether it's Singapore or London or Paris. So I think this is something we need to really ponder about. The second issue which was raised in the House, in the Rajya Sabha, was regarding the vacancies. Again, not without attributing the reasons to any particular branch of government, I need to mention here that we have one of the lowest judges to ratio in the world. Our number is probably 20 something, right? But in the case of the US, it stands at 107. In the case of Canada, it stands at 75. In the case of Australia, it's 41. And the number in India is decreasing. So we have a decreasing trend of judges to population ratio. It should have been the other way. We have more than a third number of vacancies in the high courts, close to 400 plus. The high court judges vacancies there out of the 1100 odd sanctioned strength. So these are very, very staggering numbers, and the numbers are no better for the lower judiciary. The district courts, out of the 23,000 odd sanctioned strength of judges, we have only 17,000 plus number of judges. again, not a very flattering number. Right? So these are something which really the judiciary and the parliament and the executive should really sit together and think about. The third aspect where I think we need to give some thought is regarding the utilization of funds. Now, I had read somewhere that the judiciary has been asking for more funds for better infrastructure, for better court structures. But recently I read an Indian Justice report which talks of the 2019 scenario in the country, and apparently, the judiciary is inefficient in utilization of funds. We have honorable judges here, and I think they would know it much better than I can express, that judiciary has not been able to spend the funds allocated to it. So it's ironical probably that on the one hand, judiciary has not been able to spend the allocated funds allocated, sanctioned, and on the other hand, the judiciary is demanding more funds from the government. So I think this situation needs to be improved. And then the other big area where concern was raised was regarding the court infrastructure, which I briefly alluded to. Apparently, only 100 of the 665 surveyed district courts in the country had washrooms for women. It's unbelievable. Only 100 of the 665 odd district court washroom for women. Today, I had submitted a 0-hour question in the Rajya Sabha. Unfortunately, the House got disrupted regarding having washrooms in the national highways. So I had argued that there should be a washroom or a restroom, at least for women, every 50 kilometers. And then we have a scenario where our courts don't have washroom for women. I mean, this is something which really needs urgent attention. And I'm also told that more than 50%, 54% to be precise, court complexes do not have designated waiting areas. And we have witnesses from both the genders. We have witnesses we have the stakeholders who come to the court who are old, who are sick, who might be infirm. So if we don't provide them adequate waiting areas, if we don't provide them restrooms, washrooms, then what kind of justice can we think of providing? So these are some of the concerns which were raised. Concerns were also raised regarding the independence of judiciary. Without going to the specific appointments, I would share the concern of my fellow colleagues when they articulated that this is one of the fundamental political challenge before the court, that it needs to exclude itself from the influence of the executive. And here I'd like to quote Justice Krishna Iyer, the formidable Justice Iyer, and I quote him: "During the career of judges, many carrots are held out to defect judicial performance from the path of rectitude. Judicial afternoons and evenings are sensitive phases, the incumbent being bothered about post-retirement prospects. The executive plays upon this weakness to bend the integrity or buy the partiality of the elderly brother," unquote. This is Justice Krishna Iyer. In fact, even in the Constituent Assembly debates, legal luminaries like P.K. Sen, K.T. Shah, H.V. Kamath, K.S. Santanam, they spoke of the specific need of the Constitution to prohibit such employment. The Law Commission reports, numerous Law Commission reports have come down heavily on this practice, arguing that not only does it affect judicial independence, but also it erodes the dignity and the elevated status of the judicial office. And probably it's also an assault on the independence of judiciary, which is one of the core elements of the basic structure doctrine, as we all know. Collegium, fellow MP spoke of the collegium system, which unfortunately the Supreme Court struck down, the NJAC. So there was almost unanimous consensus in the House, cutting across party line, for review of the NJAC judgment. So with all due respect to the judiciary, I have my own personal views that probably it has the time has come for the judiciary to, or for the Supreme Court to constitute a larger bench to review the NJSC judgment, or for the Parliament to come up with a new piece of legislation to replace the NJSC Act, which was overturned by the Supreme Court. Judicial activism, many members spoke of judicial activism, or the judicial overreach or overstep, whatever phrase you might use, is not because the judiciary enjoys legislating, or the judiciary enjoys, encroaching upon the turf of the Parliament. It has largely been so because the Parliament has not done its job, which the Constitution envisages. So, and particularly when the fundamental rights of the citizens of this country are being trampled, or when the fundamental rights of the citizens are at the risk of being trampled, then the Supreme Court or the constitutional courts have no option but to step in. Well, I think I was allotted 15 minutes, so I have probably spoken for 15 minutes. But I think this has been. Hello.
Yes, sir. You're audible, sir.
Okay. So yeah, but anyway, thank you very much for inviting me to share some of my thoughts. And incidentally, we discussed these issues in the floor of the House this week. So it was a great opportunity for me to share what my fellow MPs have deliberated upon, and has been a great learning experience speaking to luminaries who spoke before me. And again, I thank Professor Karad for the great platform that you are providing to hundreds of thousands of students across the country by providing quality and holistic education. Thank you.
Thank you very much indeed. Sir, you being the member of Parliament of Rajya Sabha, and as well as the legal and business from the field of legal and business advisory, you brought a completely different perspective into this particular conference symposium, I would say. So thank you very much for taking time out and sharing your thoughts and views with us. It was indeed a pleasure listening to you. Thank you, sir. Thank you very much. My friends, now it's time when I invite the special guest of honor of this session, the member of United Nations International Law Commission and consultant of ISLP. We have with us Dr. Aniruddha Rajputji. But before I invite him to address the gathering, I would like to request my technical team if they can please relay a small film made on life and work of Dr. Aniruddha Rajputji.
Dr. Aniruddha Rajput is a member of the United Nations International Law Commission. He served as the chairperson of the drafting committee of the International Law Commission at its 69th session in 2017. He advises and appears on behalf of states and private entities before international courts and tribunals, and currently practices as a consultant, public international law and international arbitration at Withers LLP in London. His areas of research, writing and practice are general international law, law of the sea, boundary disputes, international trade and investment law. He has published and lectured in these areas. He was a visiting fellow at the Max Planck Institute, Luxembourg for international, European and regulatory procedural law. He is a member of the Governing Council of the Indian Council of World Affairs. He was a member of the study group constituted by the Law Commission of India to revise the Model Bilateral Investment Treaty, and member of the 5th Haryana State Finance Commission constituted under Article 243I and 234Y of the Constitution of India. We warmly welcome Dr. Aniruddha Rajput.
Thank you very much for that film, and we all are eager to hear your views and a completely different perspective all the way from United Nations. Over to you, sir.
Thank you. Thank you very much. Firstly, namaste to you all. I had conveyed that you should avoid making a clip and simply introduce me in the most simplest of the ways. It's a bit odd to be projected so much, but I felt a little bit happy because while you were doing your research, you found a picture where there's my mother and my father. So I'm sure at least they would be pleased that our son is doing something interesting in life. So thank you for that. Since I'm myself from Pune, I must say how pleased and honored I am to be here, although virtually. It's not the first time I'm on MIT campus. I've been on the physical campus. I remember long back when I was a student myself, I came to speak at a conference, and then I came once to give a lecture as well, and it's very nice to be here on an online platform. I must begin by saying MIT is really blessed. I say it is blessed because it is in the shadows of Sant Gyaneshwar. It's a great privilege to be within the periphery of 30 kilometers from a person who's still sitting there in a meditative state and gave the biggest principle of world peace. So as long as you are under his shadow, I'm sure you're going to progress and you're going to give a very interesting ideas to the world to progress. And as this issue has come up in the discussions before as well, and I'm reminded of what Samartha Ramdas had said, सामर्थ्य आहे चळवळीचे जो जे करील तयाचे परंतु तेथे भगवंताचे अधिष्ठान पाहिजे, which simply means anybody can do a movement, but the movement will never be successful, the effort will never be successful unless it has a strong spiritual support, a spiritual backbone. In our culture, you can reach to moksha, liberation, only if you have dharma to begin with. So I'm very pleased that you're doing a very good job, so I would congratulate you on that. Now let me express some views about the theme of the conference today, the relationship between law and peace. My views might sound radical, but I think that's what my duty is as an independent scholar, to have those views and express them freely. I have always felt law is anathema to society. Law is anathema to peace. What I mean by anathema is law contradicts peace. The more law you have, which means that less peace there is. There is an inverse proportion between law and peace, philosophically speaking. If we are in a situation where the world is absolutely peaceful, we would not need any laws. So the fact that there are laws means that we don't have peace. So we need to get that relationship quite clear in our minds. And if we have that relationship quite clear in our minds, then it tells us that if we want to achieve peace, then the law needs to be geared to achieve peace. And then we need to ask, are our laws geared to achieve peace? There is a very interesting documentary which I was watching a few days back on Netflix called Inside Job. This documentary is about the financial crisis. And what the documentary tells us is that the financial crisis and all the laws which were made around the financial crisis were basically geared towards supporting the 1% of the world who have the 99% of the wealth of the world. So if the laws are made with the objective of protecting certain people who have special interests, then how do you expect such a kind of law to achieve its goal? So the object is, what should be the goal of the law? And if the goal of the law is to achieve peace, then such a law is bound to be effective. Now let me speak in my context of my experience of the United Nations, in the context of the UN Charter, which is the starting document for modern international law as we understand. When we open the UN Charter, we have to wait for the second paragraph of the preamble to come to the word peace. Because in the Western culture, justice is more important than peace. There is a Christian concept of just war, which Hugo Grotius, who's known as the father of contemporary international law. Unlike us, for us, Kautilya is the father of real international law, because he came up with concepts much ahead of Hugo Grotius. And there was a difference, because Hugo Grotius was writing a paid brief for the Dutch East India Company in order to suit the interests of the Dutch East India Company. But Chanakya wasn't writing to make a career out of it. He was writing for our interests. So we can trust him. It is what we call in our spiritual language Atmavachan. The words of somebody who's interested in your interest, in your growth, rather than his own personal interest. So we should take him, Kautilya, more seriously. So on the relationship between law and peace, we do find there is a lot of emphasis on justice rather than peace. And therefore, we do see the preamble of the UN Charter starts by saying, we the people of the United Nations having decided to save the succeeding generations from the scourge of war. So we can't forget the reason for starting of the UN was the concern about the Second World War. And that is one of the reasons why Asian and African states have always criticized the UN by saying that it was your war, you fought there, you took our people to kill us, and then you said it's a world war. It wasn't a war in Asia and Africa. But be that as it may, the fact of the matter is there was a war and there was a group of people who thought that we need to come out of it. And in order to respond to the scourge of war, they decided to have the UN Charter. So they had the UN Charter, and what's the objective now of the UN Charter? The goal that they want to achieve through the UN Charter is not to have war at all. But is no war equal to peace? That's another interesting argument. Some will say, oh, there are no wars, so everything is peaceful. Like, look at the times we are living in. There are no wars happening, but is it a peaceful time? Of course, there are several skirmishes, several use of armed forces happening in different parts of the world. I don't want to get into the details, but you all read the newspapers, the conflict in Armenia, the conflict in Palestine, which has been going on for some time. But we don't have a classical war which the United Nations wanted to stop. So technically, United Nations is successful. But do we have the peace? Probably the answer is no. So what our ancestors did, and I want to start from there, or rather I want to bring us all there. What our ancestors did, they emphasized a lot on importance of peace. They knew if you have peace, a lot of other things will be solved automatically. In fact, it's a very interesting society we had. If you look at all the Shastras are voluntary regulation. The goal is that the state should have minimal intervention. In fact, there's a very interesting discussion in Shanti Parva about when Yudhishthira asked Bhishmacharya, why law? Why state? Where is the authority of state? If you ask Austin, Austin says it's the command of sovereign. Just because I have power, I'm going to force you to follow. But that's not what Bhishmacharya says. It is dharma. The authority of law comes from dharma, not from its power to enforce. So what we see today is we have so many laws and nobody follows. In India, we are a classical case. And I think we should accept it. The problem is we are good at diagnostics, but we are not good at acknowledging what are the problems and how to solve them. Unless we change that mentality, we are never going to solve any of these problems. So that critical factor is trying to understand what is the goal, what is the objective of the law. So that's what our ancestors thought. Our ancestors thought we can have a self-regulation, we can have a very good self-regulation, but we need an apt society. But if we look at the status of our society today, there are a lot of questions to be asked. If someday Sant Gyaneshwar decides to come out of his samadhi and just do a quick check, where do we stand? I doubt if we can stand in front of him and tell him that we are proud of being your successors. Not at all. He would say probably my successors somewhere abroad have understood my philosophy way better than you guys have. So it's time for us to ask ourselves, have we brought that philosophy in our life? If we have brought it in our life, then we would have peace inside. And if we have peace inside, then we'll be able to manifest the peace outside. So manifesting peace outside is not going to happen automatically. The manifestation of peace outside has to start from a process of internal manifestation, internal reflection. And externally, we need to see what is the goal for making a certain law. You know, we had a very eminent member of parliament who gave a very interesting speech. It's always good to listen to members of parliament giving you learned speeches. Nowadays, the learned speeches have disappeared from the discourse because there's always screaming and all sorts of things. You need peace to have a learned discourse. That's why we have Shanti Part in Vedas, which speaks of peace. So we need to have a discourse, but we need to have a discourse which is geared towards achievement of peace. There have been a lot of discussions about the problems with the judiciary, problem with the functioning of courts, problem with the functioning of lawyers, which unfortunately no one speaks about. I've practiced in the Supreme Court for the first 6-7 years of my life. And most of the things which are done by lawyers in the Supreme Court are absolutely unacceptable by the standards which are followed here in the United Kingdom. I'm a qualified barrister here. So we stand nowhere in comparison to professional standards, and nobody even wants to talk about the responsibility of the lawyers. The reason being, we have created our silos, we have created our forts. We shouldn't be criticizing judiciary, we shouldn't be criticizing lawyers, we shouldn't be criticizing litigants. And if anybody gets criticized, then no, you are doing something odd, you're doing something wrong. That's not what the culture of this country was. The culture of this country was an argumentative Indian. Amartya Sen's book, our tradition is of speaking. We need to start speaking amongst ourselves first. Then we should think of bringing peace around the world. I think we have to find answers to our own problems. I see that I don't have a lot of time. I just have a few minutes, so I'm not going to keep rambling, and I'm going to start very rapidly come to my conclusions. So what are my takeaways? What is my analysis? I don't want to speak about grand international law ideas. I can speak for hours about how to achieve that at the international level. But I think there's a concern that we need to start seriously reflecting about ourselves. Because we as a country, what are we contributing to these processes? Of course, it's a great achievement to have a World Yoga Day, but a mere advertisement of Yoga Day is not going to help. We need to find out what is a specific contribution that we as India have made to the discourse of international peace and security. That's the first question we need to ask ourselves. It's not just about having Twitter accounts and enjoying and telling the world we are on the Security Council and having nice posters. What is our idea? What is our objective? If you ask the Chinese, they have a very clear objective in their minds. We don't. But as we are trying to find solutions, we need to really start finding solutions, because we are very good at diagnostics. We are very good at finding problems, and we have several problems, and everybody comes up in a conference with a host of problems. But you ask about solutions, nobody is willing to do that. It's high time now we start looking for solutions. I've always found it quite difficult at these conferences, because we all talk about problems all the time. We all know the problems. We all have World Bank data. We are faring extremely bad. If we think we are great, we are fantastic. Our ancestors were great. We had great traditions. But if we are living up to it, answer is no. There's no point comparing ourselves with the US and the United Kingdom. Unfortunately, the reality of today's time is smaller countries like Bangladesh, Vietnam, Malaysia have gone way ahead of us. I'm not even speaking about Singapore. Singapore is in the league of US and UK. I've been to these countries, I've seen how these countries function, how their judiciary functions, how their lawyers function, how their litigants function, how their society functions, and how they contribute to the making of international law. If you look at them, unfortunately, we have lost the race even with them. And these are the ones who started after us. They became independent after us. We are still in this great grand idea of India is great, and we are still, of course we are great. But that greatness has to be manifested. That greatness has to be shown. It's not by telling myself I'm great every day. It's not by seeing my nice video on my CV about how great I am, I'm going to feel happy. No, that's not what matters. The point is, how hard have I worked? How good have I put my points across? And I feel, unfortunately, we as Indians are heavily lacking in that. We need precision. We need to know what we are doing, and especially the younger generation. And what I do feel is, many Indians proudly say, I don't speak any Indian language. Nothing to feel proud about it. You should feel ashamed about it. Probably you should know, if you know an Indian language, your marketability for getting a job is much higher, because people will think you know one more language. Forget about Europeans who speak their own language, speak the English language, and speak one more foreign language. So my suggestion is, the young people need to first learn their own languages well, know the English language, but also learn a foreign language well. You might say, why am I giving this general discourse? This general discourse is an integral part of changing the psyche. And what I see is, we are not changing our psyche. We are still in that grand age where I remember Jawaharlal Nehru had said once that, don't worry, we are free now and we are going to do everything for you. And nothing happened. Not that nothing happened, several things happened. But they didn't happen the pace at which the country needs it, the country desires it, the size of the country. There's several things. I'm not going to get into specifics about do X, Y, Z. I have had the chance of giving some of them to the law minister some time back. Let's see what comes out of it. But what is important is, we start looking at how we start solving these problems. Let's stop talking about the problems. We all know what the problems are. We start taking about responsibility ourselves. If you are going to qualify as a lawyer, you ask yourself, is my performance up to the standard? If not, what do I need to do? if I'm a judge, am I performing up to the standard? You know, there's a notion that once you become a judge, you are above everything. And I'm sure that Judge Gyansudha Mishra was an exception to all this. So we revere her, and I'm very glad she's here. But I'm sure that if she reflects back on the situation, she would have a lot more to say, which she can't say in public, and she should not, because we have to respect individual dignity. But there is time we start asking questions to ourselves, otherwise we will never find solutions. The world is moving fast. The world has moved way ahead of us. We are stuck behind. We haven't had any reforms in 70 years. We have had very minor reforms. We might point, oh, we have done this, we have done that. But if you look at the grand scheme of things, we haven't done much as compared to the world. It's really time that we wake up. We have a cold water bath. We need to. Probably my generation behind, we can't do much. Our time is gone. It's your generation, who the future generation, which is to take up the job. We are happy to provide the advice. But if you don't have internal peace, you're not going to have external peace. So you need to realize the importance of legal reforms, but legal reforms based on what objective you want to have legal reforms. Ronald Dworkin wrote a very interesting book called Taking Rights Seriously. He was trying to say what is really the objective of law, and he just spoke it's about liberal rights. It's just about rights. Is law just about rights? What are the different angles? Or is it just about duties? That's a very famous rhetoric in India. Law is just about duties. No, law is not just about duties. It's about rights plus duties. But what is the goal? What is the driving factor? And that is peace, and how to achieve that. I'm sure there's a lot to say. I've probably exceeded my time. My apologies for rambling and not being on the point on certain occasions if I was, but I thought some things were necessary to be said. And I hope my contribution is of little help, if not a massive help, because you might know when the bridge was being built by really massive and powerful people, like you're going to have Judge Gyansudha Mishra, you just had a Member of Parliament, you had Ujjwal Nikam throwing big stones to make that bridge. All I can do, like a squirrel, put a little bit of sand in between those big stones to make sure that the bridge functions well. Thanks for inviting me. It was a great pleasure to be here, and wish you all the best.
So very well said. Such beautifully articulated thoughts, I must say. It was just a formality of you to say that going here and there and during your speech. It was amazing, Dr. Aniruddha Rajputji. Thank you very much for bringing those thoughts on table. Indeed, very well said when you mentioned that the concept of peace and the law are confusing and antagonistic. And really, I mean, these different perspectives that makes the symposium very, very special. Thank you very much once again for accepting our invitation and being here and sharing your thoughts with all of us. Thank you very much once again from entire organizing team. My friends, now we have reached a juncture where we all commit ourselves to the thought that was put forward in this symposium, for which I would like to request Honorable Vice Chancellor, Sir, of MIT World Peace University, Professor Dr. R.M. Chitnis, Sir, to please come forward and read us the oath, which we all would follow at our ends, wherever we are sitting on this planet, and store and remember those words in our hearts and try to follow. I would like to invite Honorable Vice Chancellor, Sir.
Thank you, Professor Gautam Bapat, sir. Let me start. On the platform of MIT World Peace University's International Symposium on Law and Peace, we, the sons and daughters of Mother Earth, being the global citizens, assure to abide by the duties and responsibilities of an ideal citizen, and hereby affirm that we will endeavor to promote peace and harmony through the lens of law in the pursuit of justice. Jai Hind, Jai Bharat. Over to Dr. Bapat.
Thank you very much, Honorable Vice Chancellor, Sir, for that oath. And I'm sure all the participants would carry these words in their hearts. Thank you very much. With this, my friends, we have reached the conclusion of this valedictory session. I would now like to invite the Head of School of Faculty of Law at MIT World Peace University, Dr. Purnima Inamdarji to kindly propose concluding address and vote of thanks. Over to you, ma'am.
Thank you, Dr. Bapat. Namaste to one and all. I would like to quote the great living legend Dalai Lama, who once said, "Peace does not mean an absence of conflicts. Differences will always be there. Peace means solving these differences through peaceful means, through dialogue, education, knowledge, and through humane ways." Unquote. It gives me great pride to place on record that MIT World Peace University School of Law has indeed successfully concluded the first International Symposium on Law and Peace in the virtual mode in the august presence of all the dignitaries and legal luminaries. Law cannot be understood in isolation, and this symposium has genuinely given all of us a golden opportunity to introspect and interpret law in a multidimensional manner. Thank you so much to our special guest of honor, Justice Gyansudha Mishra ji, for her valuable and extremely significant remarks. I would like to acknowledge our special guest of honor, Senior Advocate Praveen Parekh ji, Dr. Ujjwal Nikam ji, for their insightful remarks. I am indebted to our organizing chair, Dr. Lalit Bhasin ji, for his constant support and guidance. I would also like to express my gratitude to our special guest, Dr. Aniruddha Rajput ji, for his valuable comments. It is indeed my privilege to thank our beacon of hope, the chief guest for today, Shri Sujit Kumar ji, for his words of wisdom. I would like to express my gratitude to Advocate Satish Mulik, President Pune District Bar Association, for his constant support and cooperation. A special mention to our conveners, Honorable Vice Chancellor Dr. R.M. Chitnis and Dean Professor Dr. Anuradha Parashar, for being the backbone of ISLP and encouraging us in all our endeavors. My heartfelt gratitude for the source of inspiration, Vishwadharmi revered Professor Dr. Vishwanath Karhadji and Honorable Executive President Shri Rahul V. Karhadji, for being the torchbearers of peace and harmony and giving us the strength to conduct this unique symposium for heralding law to promote peace. Once again, thank you very much to all the panelists, attendees, teaching and non-teaching staff of MIT World Peace University for this spellbinding valedictory session of ISLP. I would like to finally end my speech with a couplet. When the world is itself wrapped in the mantle of night, may truth prevail and may we all march the way ahead by heralding peace and harmony through the lens of law. Thank you very much. Jai Hind, Jai Bharat. Over to you, Dr. Bapat.
Thank you very much, Professor Dr. Purnima Inamdarma, and thank you very much for those concluding remarks and vote of thanks.
Thank you, Dr. Purnima, for that wonderful vote of thanks. I'm just getting in for half a minute. Professor Bapat, you did a fantastic job. The way last, and of course, the Madam Bakshi and Madam Bhattacharya, all of you have done a great job of connecting the dots, and I really appreciate the efforts, and in particular the student community who really worked so hard. And I shared little my mind in the inaugural program. And it was truly a very fantastic, historic first international symposium for the world peace. And thanks to Lalit Bhasin Sahab, because of that very foundation, sir. I remember those 4-5 important meetings. I personally met you there in Delhi for twice. And further you added Dr. Parashar. We have to be really thankful because every topic was chosen so in detail. With a lot of deliberation and discussion with Lalit Bhasin Sahab and some other important lawyers under his chairmanship. Madam Sudha, Justice Madam, thank you so much, Gyansudha Mishra ji, and all the members here, Nani Grupani ji and everybody. I just thought of just getting, though it was not in the itinerary, my today's speech, but I felt like just I have become a little emotional that this very historic one such platform we could institutionalize with the support of each and every member, the Vice Chancellor and everyone here. And of course, the very DNA of our founder, there was some little praise for me in between, but I must say that all the MIT fraternity, there are over 7,500 people work in this education center. There are various institutions, universities, schools, hospitals, but the very thought and that essence, what we talk about, the very connection of law and peace, what we have been discussing and trying to do this very effort. This very seed thought has come through the mind and heart and soul, and that very preachings, the relentless preaching of our founder, revered Dr. Vishwanath Karhad sir. So thank you so much. We bow down in front of him and his vision, what he has given to this very unique institution in the history of mankind. One such professional institution. There are many various peace institutions, but I must say that for one professional institution, such a vision that how to really unify the science and technology and various such aspects of education with the peace, the professional institution, this is one such vision for the first time has born here in city of Pune, the great historic city. So thank you so much once again, each and every member. Thank you so much. Jai Hind, Jai Bharat.
Thank you, sir. Thank you very much for your kind words, and we've always been the pillar of these activities. Thank you very much for creating the platform for the brainstorming on such important issues of national importance. Creating the platform for first International Symposium on Law and Peace was indeed a very, very important and remarkable step forward. So once again, on behalf of the entire organizing team, I would like to thank you for your continuous guidance and support. Thank you, sir. Thank you very much.
I would just like to have a final word with your permission, because I want this conference to end on a very positive note. And my response to Dr. Anirudh Rajput is that India's biggest achievement has been that we have constantly for the last 70 years or so maintained rule of law in this country and the democratic values which are enshrined, you see, in our constitution. And we have given to ourselves during this period one of the greatest constitutions in the world. And we are committed to that. And that commitment includes, you see, our credentials for securing justice for everyone in the society, whether it is social, political, or economic. So let us end on a very positive note that these are our biggest achievements. As you compare it, you see, with our neighborhood and the other countries, I think India is a great nation and it will continue to be so. Thank you very much. Thank you.
Thank you very much, sir.
Thank you, Bhasin Saab, for that wonderful, last few words. I forgot to mention about great support of Mr. Nanik Rupani and in particularly the advisory board of School of Law. Very, very important board. All the members, there are 12 members, I think Dr. Inamdar and everybody has spoken about them. So once again, I say thank you so much for the advisory council of the School of Law. Thank you.
Thank you very much, everyone. And with this, my friends, we have reached the conclusion of first International Symposium on Law and Peace. Let us commit ourselves to be part once again of the second International Symposium on Law and Peace. With this, I would like to conclude the session, but before that, I would like to request everyone to rise in their seats for National Anthem. I request my technical team to kindly relay. Thank you very much, everyone, for participating wholeheartedly in first International Symposium on Law and Peace. And now, with the permission of Chair, I would request the session be concluded.